start. This is a continuance. We're coming out of recess from yesterday for our July 8th and July 9th, 2020 Land Use Commission meeting. Our next agenda item is scheduled to be a continuance of the matter that we took up yesterday regarding the Central Maui landfill, but I'd like the concurrence of the commission that we'll take up Pulelehua first and then move on to allow for the continued participation of Commissioner Higashi. I don't think we need a vote on this, Dan, just an assent. Is that correct?
Which Dan are you asking?
Dan or Denker?
Yes, that's correct. 3 Dans.
Yes, we have 3 Dans. Okay, so seeing no objections, our next agenda item is an action meeting on docket number A04751, the petition of Maui Land and Pineapple to approve the form of the order in this matter. This commission met in Kahului, Maui on December 4th and 5th, 2019 on docket number A04751 and voted to grant, with conditions, petitioner Maui Ocean View's motion to amend the decision and order dated June 30th, 2006, and to recognize the petitioner as a successor to Maui Land and Pineapple Company Limited, to acknowledge the proposed development layout for Pulelehua, to amend the 2006 decision and order to allow rentals as well as sales, development of a private water treatment plant, development of a private wastewater treatment plant, amend the number of workforce housing units, and to clarify that development conditions do not apply to the County of Maui Public Works Department, subject to the approval by the chairperson and authorizing the chairperson to approve the conditions contained in the stipulated decision and order, and that the staff would incorporate the conditions contained in the stipulated decision and order for the commission's final review and final approval. At that meeting, prior to voting, all commissioners affirmed they had reviewed the record and transcripts in this docket. On June 30th, the commission mailed the July 8th and 9th, 2020 notice of agenda to the parties in this matter, as well as to the statewide and Maui regular and email mailing lists. Will the parties on this docket please identify yourselves for the record?
Yeah, good morning, Chair. Good morning, Commissioners. I'm Gil Keith Agaran. I'm counsel for Maui Ocean View. Also in the audience, I can't see them, but I believe my client, Paul Cheng, is there, along with Preston Cheng.
Thank you.
Michael Hopper, Deputy Corporation Counsel, representing the Maui County Department of Planning. With me are Planning Director Michelle McLean and MQ.
Good morning, Deputy Attorney General Donna Puna. On behalf of the State Office of Planning, here with me are Ronnie Funakoshi and Aaron Setogawa.
Mr. Hakoda, has anybody submitted written testimony on this matter?
Not to my knowledge, Mr. Chair.
Okay. Has anybody pre-registered to testify on this matter?
No, they have not, Chair.
Okay. Is there anyone in the audience as an attendee in this Zoom meeting who wishes to testify on this matter? If so, please use the raise hand function and I will bring you into the meeting, swear you in, and give you 2 minutes to offer testimony. I am not seeing anybody who is wishing to address the commission on this matter. We will now go to closing arguments from the parties, starting with Mr. Algaran.
Thank you, Mr. Chair and members of the commission. When Maui Ocean View made their motion to amend the decision order, their intent was to develop a rental project, and that was what they initially pursued. But after discussions with the county and then through the community engagement process that this commission allowed, following September initial hearings on the motion, we did come back with a revised proposal on the amendments, including a change to the number of workforce units that would be provided, and also at the urging of the county to provide a number of single-family lots that would also be provided. And in discussions with the community, further adjustments on how some of those both workforce units for rental as well as the workforce units for sale would be allotted. In further discussions after this commission's decision, we reached general stipulation over the proposed findings of fact and conclusions of law, including 35 conditions that are included in the proposed amended findings of fact and conclusions of law that were submitted to the commission. With that, I would submit the proposed findings, and I would be available for questions, as well as my clients in the audience would also be available if the commission has questions for them.
Thank you very much. Commissioners, are there questions for the petitioner? Commissioners, for the petitioner's client, I can admit the client in. I see none. Maui County.
Thank you, Mr. Chair. The County of Maui obviously signing the stipulated decision in order is supportive of approval of this request to amend the original decision in order, subject to the conditions provided. I do want to acknowledge County Planning Department staff's effort in working with the developer to get the project into get the original amended request into compliance with community plans and various other plans that the county has, and also get it ready for the next steps. Just to note, there has been a phase 2 application filed for this project, which is the next step that the project has to go through. That was filed this week. That will require a public hearing in front of the Planning Commission here. But I think that this project reflects a crucial need for Maui County, which will involve rental housing, affordable rental housing and rental units in West Maui, which is an area that I think you heard throughout the case, through testimony and through the evidence provided, which is a critical need in Maui County. And so the county is supportive of the decision in order being granted with the conditions, and we ask that the commission do so. We're also available for any questions if you have them on the next step of the project going forward. But I think the county is was pleased to see the project continuing to move, having the ability to move forward should the commission decide to adopt this decision in order. We also do acknowledge the applicant's efforts in working with the community to get the project to the point where it has a buy-in from state and county agencies, as well as the community groups that participated in the proceedings before the commission. Thank you.
Thank you very much, Mr. Hopper. Are there questions for Maui County commissioners? Seeing none, Ms. Apuna.
Thank you, Chair. The Office of Planning is supportive of the stipulated decision in order and the motion to amend.
Okay, any questions for the Office of Planning? Seeing none, Mr. Algon, if you have anything further to say, or if there's any questions from the commissioners for any of the parties.
Yeah, just very briefly, I just wanted to acknowledge the work of the County of Maui. I think it was, I think their assistance and their input on the shape of the project was very useful and instructive to my clients. And I want to thank them as well as the Office of Planning for the comments that they made. And obviously, I think I want to thank the members of the community that did participate in the community engagement that occurred after the September hearings. I think their input was valuable to my clients, not only to understand the importance of rental project, but also the need for the housing on the west side. So again, let me thank everyone that was involved in the project.
Thank you, Mr. Agron. Commissioners, are there any questions for Mr. Agron? I guess if there's none, I just want to put on to the record, Mr. Agron, that I've heard nothing from your client, that obviously the world is very different in July 2020 as it was in December when we met, due to the pandemic as well as the associated economic downturns. But I'm not hearing anything from your client that suggests that timelines will be altered or this project isn't moving forward. Is that correct?
Yeah, as the county indicated, he has submitted his phase 2 application. We also have submitted a draft of an amended housing agreement, which is mentioned in the proposed decision order, and we're waiting for comments on that. And we'll be working on a number of other agreements, one with the Department of Transportation, as well as an agreement that we haven't submitted yet, but will be submitted to the County Department of Environmental Management, which will outline any conditions for hooking up into the county system on the west side. But he is moving forward, and he's hopeful that he'll get through the next part of this project.
Great, thank you. Anything further, commissioners? If not, this concludes closing arguments, and the commission will now consider adoption of the order. Commissioners, before you for your consideration, deliberation, and adoption is a proposed findings of fact, conclusions of law, and decision in order prepared by the staff as instructed at the last meeting on this docket. I have personally reviewed the document as well. Is there any discussion on the matter before us or a motion to adopt?
Chair, this is Commissioner Wong.
Commissioner Wong.
Yes, I would like to make a motion to adopt this matter.
Okay. Is there a second?
To the stipulated deal, sorry.
Okay.
And Giovanni, I second the motion.
Okay. A motion has been made by Commissioner Wong and seconded by Commissioner Giovanni to approve the form of the order in this matter. Any discussion? Any further praise for the parties who all figured out how to work together? Commissioner Chang.
Yes, thank you, Mr. Chair. I would like to applaud and thank the petitioner and this community for establishing a model for community engagement and to demonstrate through their genuine engagement with each other, they can find a mutual benefit. But I really applaud the petitioner for listening and the community for engaging in a genuine way. So I hope that there are other projects on Maui that are paying attention to the process that this petitioner and the community undertook here. As again, I think it does establish some expectations on our part that this can happen. And when we see it working well, just the positive results. So again, thank you very much, Mr. Chan. I appreciate everybody's efforts in working on this, and it has made our lives much, much easier. So again, thank you. I will be voting in favor of this. Thank you.
Thank you, Commissioner Chang. Commissioner Okuda.
Thank you very much, Mr. Chair. I echo what Commissioner Chang has said, I'd like to especially thank the petitioners, both senior and junior, Messrs. Chang. We all recognize, at least those of us who come from private industry, that development is very, very difficult. Doing business oftentimes is very, very difficult. Just trying to keep profitable and keep your employees employed are very, very difficult. I think what both of you have done is a tremendous contribution to the process in Hawaii, and especially with respect to land use. And so I especially thank what you and your family have done. I thank the community, and I'll be voting in favor of this motion also.
Thank you. Commissioner Giovanni.
I would like to echo the comments of Commissioner Chang and Commissioner Okuda. I would like to recognize that affordable housing is not only a Maui issue, but it's a statewide issue. And I'm very hopeful that this project will serve as a model for other affordable housing projects that are being considered around the state. Again, I echo the comments made previously, and in particular, the petitioner, Mr. Chang, have worked well with the county and have worked well with the community. And that's what makes this whole thing great. And I'm just very hopeful that the project can be executed and move forward as planned. And I am strongly in favor of this motion.
Thank you. I'll note that at 9:17, Commissioner Ohigashi entered the meeting. Commissioner Cabral.
Yes, too, I'll be voting in favor, and I want to echo the comments of my fellow commissioners. I mean, I work in housing, and I deal with subsidized government housing, and occasionally I get to deal with a few $1 million properties, and it terrifies me that I see that agencies like our Land Use Commission and government planning departments and state planning departments are really part of the obstacle, and a huge reason why there is no affordable, quote, affordable housing is because we add to the cost of a developer or a private citizen. And I really applaud the efforts of everybody to try and provide a range of housing, because it's scary to think that we're only going to be able to have private people build multi-million-dollar McMansions, and then the government's going to come in with all the low income, and there's nowhere in the middle. And I see that as a problem, even in Hilo, where our housing's outrageously affordable compared to everybody else. So thank you to our petitioner for working with the community, and thank you for the community for coming up with a compromise, and thank you to the commission for moving ahead. Hopefully we get to come to the groundbreaking soon. Thank you. Okay, bye-bye.
Thank you, Commissioner Cabral. Commissioner Ohigashi.
I apologize for not being here. I don't think I'm supposed to be able to vote on this matter, but I'm still in support of the motion. Thank you. That's all I have to say.
Thank you, Commissioner Ohigashi. Is there anything further, commissioners? Commissioner Axon?
Yeah, thank you, Mr. Chair. I just want to thank everyone, especially the community leaders that brought this thing to the fruition. Also, the petitioners and each council. And this is just to show that, good communications without heated agenda, great things can happen. So thanks to everyone. I'll be voting in support.
Thank you, Commissioner Axon. Anything further, commissioners? I guess just to add to the praise, to highlight a couple people, I would like to thank Mr. Agaran for providing Mr. Chang able counsel during this very transformative process for them during the project. Without casting aspersions against other professionals in Hawaii, other counsel might not have so aptly guided their clients through this kind of process. So I really appreciate that. And I also very much appreciate the work of Maui Department of Planning for having been so responsive as while going through the changes in this project. With that, if there's nothing further, Mr. Ordenker, please poll the commissioners.
Thank you, Mr. Chair. The motion is to adopt the stipulated decision and order. Commissioner Wong,
Aye.
Commissioner Giovanni,
Aye.
Commissioner Axon,
Yes.
Commissioner Cabral,
Yes.
Commissioner Chang,
Yes.
Commissioner Ohigashi. Abstain.
Has to be excused.
Excused.
Commissioner Okuda,
Yes.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes with 7 affirmative votes and 1 abstention.
Okay, thank you. Congratulations. It's 9:22 a.m. The chair will do a brief 3-minute recess to 9:25 to allow us to take up the next matter of the Central Maui landfill.
Nancy Cabral.
Edmund, it is a very handsome photo you have for your profile photo. You are on time, Commissioner Cabral. Thank you.
Commissioner Axon still has to sign back in.
Okay. Commissioner Axon. I will share that in the absence of my gavel, I found this at home, so. We are out of recess. It's 9:25 a.m. We are moving back to our agenda item on SP 97390, Department of Public Works and Waste Management, Solid Waste Division, County of Maui, to consider a 4th amendment to the State Land Use Commission special permit for the proposed Central Maui landfill facilities project at tax map key 23-8003, portion of lots 19 and 20, Pu'unene, Maui, Hawaii. Will the parties please identify yourselves for the record again? Beginning with DEM.
Good morning, Mr. Chair, Commissioners. I'm Jennifer Owana, Deputy Corporation Counsel for the Department of Environmental Management. Along with me today is again Director Eric Nakagawa. Sitting behind me is Deputy Director Shane Agawa. Down there is Project Manager Elaine Baker, and across from me is Mark Roy, our consultant.
Thank you. Mr. Hopper.
Maui County Department of Planning, Deputy Corporation Counsel Michael Hopper. I'm here with Ann Kua and Kurt Wallenhaupt, and Deputy Director Jordan Molina is on its way. So, I'm sorry, Jordan Hart is on his way. Thank you.
Thank you. OP.
Good morning, Deputy Attorney General Donna Puna. On behalf of the State Office of Planning, here with me today is Rodney Funakoshi and Lorene Maki.
Okay. Commissioners, where we left off yesterday before we went into recess was there were questions for DEM and we had yet to hear public testimony from the Office of Planning. Are there any current questions at this time? You'll have another chance. Questions for DEM, Commissioners? Commissioner Giovanni.
Thank you, Chair. I just have one question to clarify to DEM. In the presentation by the DEM team yesterday, reference was made to the current solid, I believe it was called the Integrated Solid Waste Management Plan. And my question is whether that plan is currently on the record in this matter.
Referred to in the final environmental assessment as well as the planning department's report. It is not, the plan is not in the record, but it is talked about in those 2 documents.
That's my understanding. It's been talked about and referred to, but the plan itself is not yet part of the record. Is that correct?
That's correct.
Thank you.
Is there anything further at this time, commissioners' questions? I will give DM a chance to speak after OP. If there's nothing at this time, OP, are you ready?
Yes, Chair, thank you. So I was going to address some of the issues that were brought up by the commissioners yesterday. The first is what is OP's proposed condition on IAL? OP has proposed that the county be required to submit a petition for a declaratory order to the commission to withdraw the 22 acres from IAL designation within 1 year of the Land Use Commission's approval of the decision and order for this special permit. OP has not offered any other alternative for the county regarding the 22 acres of IAL, as Commissioner Ohigashi had mentioned or questioned. The 1 year would allow the county an opportunity to determine whether the removal of the 22 acres would significantly affect the majority of lands of the original IAL petitioner, Alexander and Baldwin's land holdings that were put into IAL in protection of all other of its land holdings from designation by the county pursuant to HRS 20549. I understand that the IAL deck petition was for 27,000 acres, and this is 22 of those 27,000 acres. The reason why OP has suggested that the county remove the 22 acres from IAL is that as a landfill, it no longer meets the definition of IAL. However, the landfill is not necessarily required to be reclassified to the urban district through a district boundary amendment as mentioned yesterday. Why a special permit rather than a district boundary amendment for this landfill? A special permit as opposed to a district boundary amendment is more appropriate for several reasons. A landfill is not necessarily an urban use as some had indicated. It is an unusual and reasonable use of the ag district for which HRS 2052 and 205.4.5a do not expressly permit and which are not contrary to the purposes of HRS Chapter 205. That is what a special permit is for. Those uses not expressly permitted, but may be reasonably allowed in the ag or rural districts. A special permit is not a mechanism to allow urban uses within the ag district. If a landfill were an urban use, it would be contrary to the purposes of Chapter 205 to allow it in the ag district and would require a variance or district boundary amendment. Special permits are also temporary in nature. The use is not thought to be a permanent use. A landfill is temporary in that it has a limited lifespan. The county stated that the landfill has sufficient capacity to operate through, I think it was 2030. When it reaches capacity, it no longer can serve as a landfill and potentially could be used once again for some type of agriculture. It is uncertain at this time what that future use will be, but it will not necessarily be urban. It's premature and purely speculative to say that the area will be used for urban use and that therefore a DPA would not be appropriate at this time. Should the commission allow the removal of the 20 acres from IAL, and more specifically, because of its IAL designation, is it protected from withdrawal? There's nothing in the statute prohibiting the commission from removing the 22 acres from IAL designation. The required 2/3 vote by the commission under Article 11, Section 3 of the state constitution and HRS 205.50F is specific to a district boundary amendment or zone change involving IAL lands where the underlying district or zoning of the IAL land is changed from agriculture to urban, rural, or conservation. The 2/3 vote is not required here for the withdrawal of an IAL designation from lands that will remain in the agricultural district. HRS 205.50G provides that a landowner may remove the IL designation if a sufficient supply of water is no longer available to allow profitable farming of the land due to governmental actions, acts of God, or other causes beyond the landowner's reasonable control. This is the only provision that addresses the withdrawal of the IL designation from ag lands. OP believes that without a specific provision to address this situation, public policy dictates that the 22 acres, which will serve an important public service to the county, is a legitimate use of the agricultural district, but not consistent with the provisions of IL and should therefore be withdrawn. The commission is empowered to remove the IL designation under HAR section 15-1598A. This type of situation or scenario in which the LUC may use its discretion and authority to remove the lands from IAL designation and to allow this public benefit is, and it's an important opportunity for the LUC. This is only 22 acres in IAL, and it serves an important public benefit. So I think it's a matter of the commission weighing those two things, and I think the county can provide more about why these 22 acres are important for the landfill site. Additionally, the commission, if they are concerned that the special permit approval will precede the removal of the IL designation, there can be a condition that, or there is the condition that we have proposed to require 1 year within which the county will move to ask for the removal from IL designation, and not do anything upon the 22 acres until the designation is removed. That is it. Thank you.
Thank you, Ms. Apuna. Commissioners, are there questions for Ms. Apuna? Commissioner Okuda.
Thank you very much, Mr. Chair. Ms. Apuna, thank you for your explanation. Just to lay the cards on the table, your analysis pretty much convinces me that as far as the analysis, but this is my question. I understand your analysis about why you consider the use not to be an urban use. What do we do with the fact that when I asked that specific question of DEM, their response, as I recall, was that the proposed use of the property was urban? I mean, that's their response on the record.
Right, and I think you might want to give the county an opportunity to revisit that question. Perhaps they might have might be able to explain that, but yeah.
Okay, well, just so that I'm clear, can you explain again, or explain again why you believe the use is not an urban use?
So I think there's plenty of reasons why it's not an urban use. It's not something permitted expressly under 205 as a urban use. I think urban uses are considered city-like concentrations of people, structures, and facilities. I think that the history of landfills throughout the islands are generally within the ag district. They aren't in urban districts. And I think also that a lot has to do with the surrounding properties of landfills. They aren't necessarily welcome or properly sited in urban areas. They're probably better fit for agricultural districts that are open and you don't have as many neighbors nearby that would be affected by the landfills.
Okay, thank you very much. Thank you, Mr. Chair. No further questions.
Thank you. Commissioner Giovanni, followed by Commissioner Ohigashi.
1 second, please. Just make a note. Thank you, Ms. Apuna. I want to follow up on your discussion with Commissioner Okuda. My perception of the petition is primarily one that would add 40 acres for diversion and recycling activities consistent with their integrated solid waste management plan. And what we're seeing in that industry across the state and in other locations is a movement to invest in processing technologies that convert waste and really minimize the requirements for landfill per se. In effect, this particular landfill, which was, as you noted, originally estimated to reach capacity by now says if nothing happens, they'll reach capacity by 2026. And if they put in this first phase of diversion and recycling activity on the new 40 acres, their estimate is 2042 before they'll reach capacity. And that's with the technology they've already identified. So my question is, would you still, with all of that, would you still contend that the activities and the processes and the investments to be made to the new 40 acres, not to the landfill per se, is still best categorized as an agricultural use and not an urban use?
I'm not sure how to answer that question. Yeah, I think that it is an unusual and reasonable use, the landfill. And so you can't necessarily put it definitely within the urban district or as a traditional agricultural use. It's kind of in between or in a gray area, but it is unusual and reasonable to be within the agricultural district.
So are you suggesting that if on a given piece of property or land, if any part of it is used for landfill, that the landfill would govern how that entire activity is to be judged? Because I actually see the landfill operation becoming a minor part of the operation as time goes forward.
I'm not sure. I don't know. I think I would defer to the county as far as.
Okay, well, we'll let the county speak to that point. My other question has to do with your contention that this is not a permanent or long-standing, that it would actually have a term to it. And I think you noted 2030, but I think that the representation from DEM is that with this current phase, they're looking at 2042. But there were numerous comments made yesterday by DEM that this is basically viewed as a permanent investment, and rather than having something that terms out and reverts back to another use. Could you expand why you think that this is not a permanent plan?
So I think that, you know, at 2042, the county will follow the DOH's regulations, and they'll have to, you know, cap it and landscape it and bring it back to as best as possible, you know, land that can be usable for other uses. And I'm not sure if the county's perspective is a little bit shorter than what I'm talking about, but we're talking about maybe 100 years, or, you know, I mean, not necessarily just up to 2042, that beyond that, there should be other uses for that land. And we can't foreclose or say definitely that this will always be a landfill or that it will always be urban use, that it has potential to be used in other ways, even agricultural uses.
Thank you. That's all, Chair.
Thank you, Commissioner Giovanni. Commissioner Ohigashi.
Thank you, Commissioner Giovanni, for asking the two questions that I wanted to ask. The third question that I want to ask is essentially the question as to your reading of how a declaratory order would be able to remove the IAL designation. Now, I'm looking at 20552, which tracks, I think, 20550G, and it states that important important agricultural lands designation shall be removed from those important agricultural land where the commission has issued a declaratory order that sufficient water supply is no longer available to allow profitable farming on these lands due to governmental action, acts of God, or other causes beyond the farmers or landowners' reasonable control. Would you agree with me that that would be the standard to remove the important agricultural lands designation?
I would say that that is one of the avenues or one of the scenarios in which the commission may withdraw the IL.
Could you point me out? Could you point out any other statutory criteria for the withdrawal of important agricultural lands?
I think that there's. Well, I think that the declaratory order process under 1598 HAR.
Well, that's a rule. I'm asking, is there any statutory criteria established?
I think that's so 1550-98 is based on HRS 91 as far as declaratory orders and the authority of the commission to make orders. So there's statutory authority for the commission to do so and to modify the current IAL deck petition for this land.
So under what criteria would we use to remove it that you're suggesting?
I think it's looking at what the same criteria that you use to identify and declare land as IAL and whether it still meets those standards. And if it does not, then you would withdraw it. It's almost like a reverse process.
Is that process outlined or authorized that we be used in any statutory authority?
I think that it's reasonable that that would be your avenue to remove it.
The second thing is that, so the answer is no, right? But you believe it's reasonable. The second question I have is there any case authority that you can cite that will allow us to create a new standard or create these standards for removal when the statutory standards are already indicated under 20552G or 50G?
No, there isn't any case law that I'm aware of, but yet this is breaking new ground for the commission, but I don't think you're in any way prohibited from doing it. And I do think you have the authority to withdraw it from IAL. And it makes sense.
Would it be in our best interest then to request a written opinion from our Attorney General's office, Mr. Morris's office, to be sure that we can proceed in this fashion, thereby putting the opinion of the Attorney General to proceed in this fashion? Will you say that it is prudent?
Yeah, that's certainly within your discretion.
No. I lost everybody for a minute.
No, they're still here.
So, is there any? I'm gonna ask you about because if you review the record, did you review the record in this case?
Not completely.
Okay. The reason why is that when I looked at the exhibit number 6, which appears to be the Planning Commission or the Planning Department's staff report in this matter, which is part of the record, what their argument was that you can do this on this IAL lands, so long as you meet the criteria for boundary amendment. And I'm looking at page 8 of that. Have you had an opportunity to review the rationale that they use in terms of
I think,
how
so
they
actually,
determine whether or not they can bypass the IAL requirement?
I think there might be some confusion there. I know under HRS 205-50, there are standards and criteria for the reclassification or rezoning of IAL lands, and that's not the situation here. They're not trying to change the zoning or take it out of ag. They're just asking to withdraw the IAL lands, or withdraw the lands from IAL. And the only,
However, I just want to make my point. However, in the staff report that was adopted, I believe, by the Planning Commission, they indicate that they believe that they have sufficient basis for a boundary amendment to meet the boundary amendment, thereby creating an argument that the IAL lands can be this requirement about getting this requirement about IAL lands should not be applied, since we can meet the boundary amendment requirements. That's what I was reading in this. Correct me if you haven't read it. That's fine. I'll ask the county.
I haven't read it. I can just say that I think, can I just
go ahead.
Answer though, that I think that even if you do apply if the county has applied these criteria to this situation, I think that just shows that they have met some higher standard, but that I'm just saying that these standards don't necessarily apply to this special permit. So I don't think there's any fault, or it shows that they've reached a standard rather than that they're somehow deficient in any way.
Thank you. I'm just trying to find out what was in the record and to make sure that I understood everything, all the arguments here. Okay. No further questions.
Thank you very much, Commissioner Ohigashi. Sorry, I see a hand raised from Maui County Planning. Mr. Hopper.
I was just offering to respond to, I was present at the Planning Commission meetings during that discussion. Also, I think you typically allow, at least in my experience, the planning department to provide, I guess, public comment on.
Can you, Michael, can you back up? You're kind of breaking up for me.
What, would you like me to speak up? You said?
You speak up, yeah, and speak
okay.
clear. Thank you.
Okay. I was offering to help answer that question about the record, as I was present at the Planning Commission meeting when that discussion took place. In addition, I just offered that I think typically the planning department is allowed to participate in public comments, usually on district or on special permit requests. So we would request, if available, if that option's available, to be able to do that at the appropriate time.
Why don't you go ahead, Mr. Hopper?
Certainly. To address Commissioner Ohigashi's question, HRS 205-50, it's an interesting read. Item B, 205-50B, states that upon acceptance by the county for processing, any application for a special permit involving important agricultural lands shall be referred to the Department of Agriculture and the Office of Planning for review and comment. That's the only mention I could find in this section about special permits. It obviously contemplates that state special permits can be granted for uses on important agricultural lands. Now, the statute goes on to state a variety of criteria, some of which are premised with, for example, 205-50C2 talks about the proposed district boundary amendment or zone change. Subsection 3 talks about the district boundary amendment or zone change. But then subsection 4 simply says the public benefit to be derived from the proposed action is justified by a need for additional lands for non-agricultural purposes. And subsection C of that statute says, any decision by the Land Use Commission or county pursuant to this section shall specifically consider the following standards and criteria, some of which specifically mention the district boundary amendment or zone change, some of which do not. So given that this section mentions special permits, and this section also mentions specifically district boundary amendments or zone change, the staff report, I think out of an abundance of caution, did do an analysis of the standards as far as whether or not this project met them in order to make sure that when it went to the Land Use Commission, the commission wouldn't revert saying you didn't make any findings with respect to this section, even though it may apply to special permits. But I would argue that this section states that does recognize that special permits can be allowed on IAL. And if this criteria does not apply, then the only other criteria for determining whether to grant the special permit is HRS 205-6 and the Land Use Commission's administrative rules, which are contained in the staff report and an analysis is provided. But it was a bit, I think, ambiguous as to whether none of these criteria apply to special permits and only apply to boundary amendments. In some cases, it specifically says this is for boundary amendments or zone changes, but in others, they're not so specific. And this section does recognize that there are special permits that can be allowed on IAL. So that's, I think, what the county dealt with in the record there. I would like to address some of the other issues as well, but I wanted to first get to that issue that was raised by Commissioner Ohigashi on why.
Okay, well, so let's just see if there's a follow-up from Commissioner Ohigashi since it was responsive to his question. We're still on questioning of OP.
So following your line of reasoning then, if I'm saying, if it's correct, is that because it mentions special use permit be sent to Department of Ag as well as I think it was OP, that triggers the ability to the Land Use Commission to grant special permits on IAL lands. Is that right?
Yeah, why? Yes, I don't see, I'm sorry, one second. Yeah.
I'm just trying to follow your logic.
Yeah, there would be no reason for the legislature to have mentioned where special permits involving important agricultural lands should be sent to if it was impossible to get a special permit for any use on important agricultural lands. That was the logic there.
Is that supported by the legislative history? Have you guys taken a look at that?
Not in depth, but again, I don't know why there would be direction as to who has to review special permits on IAL if you could never grant a special permit on IAL. I think that's logic.
So now my next question would involve is
this a question for OP, Commissioner Ohigashi?
Yeah, well, this is just want to follow up on the Maui client. So would that, under the agreed upon, well, let me put it this way. DEM agrees to the condition that OP wants to remove the IL designation by filing a petition for declaratory order within 1 year. Is it your position that that declaratory petition is not necessary?
That's a difficult question. I believe that under the law, you can do uses under special permits without getting the IL designation removed. Technically, according to this, you could get a district boundary amendment on IAL without the removal of the designation. I think
with 6 votes.
Yeah, you do need a 2/3 majority for a zone change or for a district boundary amendment. But I don't, according to the law, that doesn't remove the IAL designation. It just changes the designation, though. But I think I would say that OP's position we understand to mean removing from IAL is the right thing to do because the property no longer meets the criteria. But as to whether or not you can grant a special permit with the designation still there, I think based on the law, that you're not prohibited as a matter of law from doing that simply because there's an IAL designation.
So if we decided that you have to file for we agreed with OP's position. And we said, okay, you have to file for a declaratory ruling to remove the IAL. And we determined, according to the criteria, statutory criteria, that you don't meet the statutory criteria to remove IAL lands under 20552G, 52, 20552, then the special use permit will still be valid according to your reading. Is that correct?
Yes, because there's the IAL, and I've been through this.
I just wanted to know, yes,
okay.
It will still be correct.
Yes,
okay?
yes, the answer is yes.
Okay.
I clarified.
Thank you, Commissioner Ohigashi. Are there further questions for the Office of Planning at this time, commissioners?
Chair.
Commissioner Wong.
Question for OP. I know that they advised that within 1 year, they should do a declaratory ruling on the IAL. What if we hypothetically say instead of 1 year, do it by 2028? Would OP still agree upon that? Be okay with that?
2028.
Yeah, because the special permit is supposed to end too, right? Before that, before that, within that time period.
I think the reason why we're asking for it to be removed from IL is that it is not IL. It doesn't meet the criteria to wait 8 years for that determination. It kind of doesn't make sense.
Yeah. So no, the reason I'm saying that is because of, let's say, this issue we have with the Zoom and everything's backing up. What if we can't do it within that 1 year? So we have to do it, in 2 years because, everything's backing up, things are, piling up. Is that okay? Or 3 years? I mean, just depending on.
Yeah, it's reasonable if the commission can't get to it within a year, but as soon as it possibly can would be ideal.
Yeah, so I was thinking hypothetically, what if we put in a condition that says within that period, sooner than later, you have to do that declaratory ruling to get rid of the IAL designation. I mean, would OP be agreeable upon that?
I think within a reasonable time, yes.
Thank you, Chair. Thank you, OP.
Thank you, Commissioner Wong. Commissioner Chang. Commissioner Chang, about how long do you think you have? We're right about an hour.
Oh, I'm hoping no more than 5 minutes, just to confirm some.
Okay.
Thank you very much, Mr. Chair. So, OP, Ms. Apon, I just want to clarify. I mean, it's my understanding the reason you're putting in the condition for within 5 years, it is to provide the county. Well, it's to ensure that one, there's no physical structures that's built on that IAL designation. And so it puts the motivation on the county to do that action before they start investing in building structures on the IAL property. Is that the IAL designated lands? Is that correct?
I think in part, yeah.
Yeah, I mean, and also I appreciated your reasoning, as I agree with your assessment. And the final question is with respect to your point about that the ag lands, the landfill, it could be restored. That we don't know what's the state of the art of technology. We don't know what they can do. So at this time, it would be premature to assume that it would be the more appropriate designation is urban. And I mean, I say that because I can see, what is that? The quarry. I mean, they've been landscaping. I don't know what they propose to do. So that's my understanding of why, because it's too speculative and premature at this point in time to say that it should be an urban designation, because we don't know what happens at the end of the term. Is that correct?
That's correct.
Okay. Thank you, Mr. Chair. I have no further questions.
Thank you. Commissioner Giovanni?
Yes, Chair, I know that you're angling to get a recess, and I would like to request that upon return of the recess, we have a short executive session, if possible. I have some questions of process and law I'd like to put forth to the on that in an executive session.
Okay. For us to, so let me procedurally address this before and by procedurally, I mean technologically address this prior to procedurally asking for a second to your motion. What we would need to do is to have Mr. Orodenker or Mr. Hakoda send a separate Zoom meeting link. We would log out of this meeting, I believe, and then log into executive session along with Mr. Morris, and then leave that and rejoin this meeting, which would somehow continue to operate. Do I have that correct, Scott or Dan or
Correct, Scott.
Riley?
This is Dan Morris. Yes, what we've done for executive sessions is, of course, following a motion that would carry. There would be sort of a withdrawal from this meeting into a new meeting that is set up amongst the parties to the executive session, and then we would finish that, go back and rejoin this meeting thereafter.
Thank you, Mr. Morris. Mr. Orodenker, are we ready to do that technologically if needed?
So we will be. I'll be sending out an email right now with the link.
Okay. Is there a second to Mr. Giovanni's? Okay, I see two waving hands, Commissioners Ohigashi and Cabral. Are those seconds?
Yes, I am seconding Commissioner Giovanni's motion.
Commissioner Ohigashi?
I understand that the motion is to go into executive session for consultation with our attorney concerning.
I need Dan's email address, the AG's
matters. That's my understanding, that we're going into executive session for the purpose of consulting with our attorneys concerning procedures that we're in, that are involved in this matter.
Is that correct, Dan Giovanni?
Yes, that's correct.
Okay, is there discussion on the motion? If not, Mr. Orodenker, please poll the commission.
Thank you, Mr. Chair. The motion is to go into executive session. Commissioner Axon.
Yes.
Commissioner Cabral.
Yes.
Commissioner Chang.
Yes.
Commissioner Giovanni.
Yes.
Commissioner Ohigashi.
Yes.
Commissioner Okuda.
Yes.
Commissioner Wong.
Yes.
Chair Scheuer.
Yes. So for the people who are panelists as well as meeting attendees, I believe what is going to occur is that this meeting will remain open. There will be a note somehow placed up that we are in recess, and that after that is done, we're done with executive session, we will reconvene. Is that correct, Mr. Hakoda?
Yes. Yes, Mr. Chair.
Okay, so we are actually adjourning into executive session right now. Commissioner Axon, Chang, Cabral. Thank you, Commissioner Axon. Commissioner Chang, thank you. Commissioner Cabral. Mr. Hakoda, you're reaching out to Commissioner Cabral.
Yes, Chair.
Thank you. Hi, Commissioner Cabral, we're ready once you are. Can you hear us and can we hear you? You're muted.
I can hear you and I can see you,
Great.
Jonathan. Things are not
Okay.
normal, but oh, now the screen is changing. Clearly
Okay.
issues.
And court reporter? Madam Court Reporter, you're with us?
I am. Thank you.
Okay, great. Okay, thank you to everyone for your patience. It's 11:17 a.m. We're back in session. Thanks to everybody's patience. It was our first time going into executive session virtually, so there were some technical hiccups. Sorry for the length of time it took. We were questioning the public testimony from the Office of Planning. Were there further questions, commissioners, for OP? The chair had. I had as chair. I had a question, Ms. Apuna. If I understood your statement correctly, you seemed to say that one of the reasons for keeping this landfill expansion in the agricultural district is that landfills are not expressly included in the urban district as a use. Did I understand that correctly?
Well, I think what I was saying is that under 205, it's not an expressly permitted use under the urban district.
But aren't a vast majority or a very significant number of urban uses not explicitly included in 205?
Yeah, yes, that's correct.
Okay.
Also, urban uses are, I think the statute says that they are uses as provided by ordinance or regulations of the county.
Yeah. My second question had to do with, I'm chewing over and struggling with the idea of temporary uses versus permanent uses. And I believe the way 205 is constructed is there's this implication that temporary uses can have a special use permit. Permanent uses, by contrast, need a DBA. But what makes a use not temporary? I mean, you could put in a subdivision and remove a subdivision that's been done, or remove an industrial area and return it to agriculture or conservation. So I'm particularly concerned in this case because even though it has been done before, there's probably certain things you would not do on that property after it had been a landfill. You might not put a elementary school on it, is that correct?
Yes.
Or, you know, you might do a sports field, you might not do housing.
Right.
So there is a permanent change to the property as a result of the landfill use, correct?
Yes, there could be.
Okay. So is the use really for a landfill? I mean, for a solar farm, it has an expected life and there's this, you can envision the panels are removed and then it goes back to being agricultural in nature. But for a landfill, you're not really ever going to fully restore that. You're not going to remove the waste from the site eventually, at least under current technology. Is that correct?
Right. You're not going to, it's not going to go back exactly as it was prior to the landfill, but it allows for other uses after that. You could put a solar farm on top of it after the landfill is covered, and that's an agricultural use.
But there's some things you would never do again.
Sure.
Last thing I wanted you to comment on is what was phrased by, I don't know if correctly, but by DEP as the chicken and egg argument. Why would it not be more appropriate to first remove IAL designation and then get a SUP?
I think you can, I'm not sure. Actually, I think you can do it either way.
Mm-hmm.
You know, it's not, but I don't think you're required to do it either way either. You know, when we ask that it be removed from IAL, I think it's to uphold the standards of IAL and what that means to the commission and what the commission is trying to do when it does designate IAL. But there's nothing that's requiring you to do it in a certain order, or that you're, prevented from doing one before the other.
Thank you. I don't have anything further for OP. Anything else, commissioners? If not, then Maui County, you wanted to make some comments, planning?
Yes, Mr. Chair, I want to be brief because I think Office of Planning did go over a lot of the items that I had, and then I also didn't know if DEM had responses to some of the issues that were outstanding after this, but I wanted to just address a few things. Again, OP did go over some of these, but I think what the question was asked, why a special permit was sought in this case. And I think one important fact, and I think a reasonable reason for seeking a special permit by the applicant was that this is involving two already existing permits that have been in place for decades for the operation of the landfill. I think it was reasonable for the DM to conclude that a appropriate approach would be to amend those permits for time extensions. And in fact, as I understand it, the life of the permits have expired as of today, but because there was an application filed prior to this, prior to the expiration date, the landfill can continue. But I think that was a reasonable approach based on the fact that not only were these landfills permitted by special permit, there are two other landfills in Maui County that are permitted by special permit. And it's my understanding that that is consistent practice across the state, that the majority of landfills on ag land are permitted by special permit. And I think OP outlined some of the reasons for doing that. I think one of them is that the piecemeal nature of the landfill expanding and having to add additional land isn't necessarily as consistent with the district boundary amendment process, which doesn't necessarily envision a piecemeal continuing urbanization of lands. In addition, the DBA process is a bit more extensive. I think it was commented that yesterday it was discussed that there was not any public testimony in opposition to this request, either at the Planning Commission meeting or at this meeting. There was notice sent to owners of property within 500 feet. And there was a newspaper article published. And I think it can be difficult to speculate why people would, in a case, decide not to show up, or if they did get noticed. But I think Maui has shown that if there are important issues to the community, they do not hesitate to come out and testify. And I think it's possible that if this had been a district boundary amendment for this whole area to urbanize a significant amount of acreage, it's possible that that could be something more controversial. Again, that's speculation, but I think it's based on my experience in the land use area. In addition, there was some discussion of whether the structures made this an urban area. I think that there are numerous special permits across the state where structures are part of the special permit process. I don't think that necessarily transforms something to an urban use. I think as the Office of Planning stated, urban uses are classified as city-like areas. And I don't think that, that this project would be considered a city-like in its nature to the extent that you would need a district boundary amendment. Again, the presence of structures, I would contend, does not require something to get a district boundary amendment if they're part of the, and that can be permitted by special permit. Again, if the criteria for a special permit are met in HRS 2056 and the Commission's administrative rules. And then just briefly about IAL, I think OP did clarify a few things, that legislative approval was not required for removal of the designation in this case. Legislative approval would only be required if the removal involved an area that when it was originally designated, there was a concurrent redesignation of the property, of other property owned by the same owner to urban or some other designation. I was present and represented the Department of Planning for A&B's declaratory order to request the IAL designation, and participated in meetings with A&B on behalf of the Department of Planning there. And they waived the right to concurrently redesignate their land to the urban district. And that was expressed in your decision and order. So we do not believe you would need legislative approval to change that designation because there was not a concurrent redesignation done at the time A and B requested their designation. And we also believe, just to clarify, for the special permit request, we do not believe there would need to be a 2/3 majority vote of the commission. That would be for a district boundary amendment. And I think that's been clarified, but wanted to get that clear. And I think we did clarify that we do believe that a special permit is a use that is something that can be granted by the commission while the property is still designated IAL, although there's been discussion of conditions with respect to obtaining the removal of that designation, and the commission certainly can consider that. Finally, I did want to discuss, OP got into this a little bit, but the facts of the situation I think are if you looked at the map of IAL, they essentially surround the landfill. The landfill doesn't have many options as far as expanding to meet the county's needs. It doesn't involve in some way interacting with the IAL. And the IAL represents 22 acres of 27,000 acres that were designated IAL upon A&B's request. The land's no longer being used for the purpose, the agricultural purpose for which it was originally designated, which was sugarcane. And so I think that by granting the special permit, there's not necessarily a loss of active agriculture because the situation has very much changed from the time that A&B got their designation. Finally, I would note, I think there was a discussion of, there is a limit to how much land a single landowner can have their land designated as IAL within a county. I think there was a discussion of would removing this designation allow the county to redesignate other A&B lands because you're below that 50% threshold. And I would just note, I think Commissioner Ohigashi had asked about that. I would note that the limitation on how much land a single landowner can have designated as IAL is based on the amount of land that that landowner owns within the county, or I believe it's on an island. But in this case, by selling that land to the county of Maui, that IAL land would not be considered part of the inventory of A&B. So that would be taken out regardless of whether that designation remained or if the commission ended up removing that designation. So that's all I had. Again, I think OP had made a lot of the points that I wanted to address, but I wanted to make sure to get that to the commission.
Thank you, Mr. Hopper, for those comments. Commissioners, I think procedurally where we might go now is to offer some opportunity for DEM to offer further comments and then questions of any of the parties by the commission. DEM, are you prepared?
Yes, thank you. So one of the issues that we heard yesterday is why we have been operating under a special permit rather than obtaining a district boundary amendment. And as I said yesterday, this issue has been on our minds as well. We have been wondering what is the most appropriate thing to do. And so we very well may be going into for a district boundary amendment in the future, maybe sooner than later. But I want to remind everybody, as the HCD quarry moves from one spot to the next, we follow along with them. So as this facility has expanded, it did also make sense for us to come in for amendments for the special use permit. With regard to a district boundary amendment, I'm not sure whether we would want to go for a district boundary amendment for just the current portions that we're using for the land, or whether we could anticipate where the next expansion would be. And so going in, if we were to go in for a district boundary amendment for a potential potential future expansion, that is a little bit concerning, only because we don't have control over that land yet. We may never have control over that land, and if we go in for a boundary amendment, to like urban, essentially we would be asking a portion of land to be urban that we will never use as a landfill. So then now we have an urban parcel out there that could be really used for something not wanted in that area. Commissioner Okuda, I believe, brought up yesterday a Supreme Court case, Neighborhood Board number 24 versus the State Land Use Commission. And so he brought that up to basically ask us if we analyzed that, and I'm sorry, we did not analyze that. But that case, it involved a proposed use of land in the Waianae Coast for an amusement park. The Supreme Court specifically noted that allowance of a special permit for the development of a recreation theme park covering 103 acres of ag land, which will attract 1.5 million people to the Waianae Coast, frustrates the objectives and effectiveness of Hawaii's land use scheme. The Supreme Court did say, as Commissioner Okuda pointed out, that they did not believe the legislature envisioned the special permit technique to be used as a method of circumventing the district boundary amendment procedure to allow the ad hoc infusion of major urban uses into the ag district. However, right after that, the Supreme Court stated that the theme park proposal was not an unusual and reasonable use and was more properly subject to a district boundary amendment. Now that case is distinguishable from the present situation, whereas with a theme park, it would generate a lot more people, more traffic, more needs for public services such as water, police, fire, emergency services. And this project does not create that much of a need. As stated in the record, in the final environmental assessment, as well as the report from the Planning Commission. This is not the kind of urban use that the Supreme Court was analyzing in the Waianae Coast case. The Supreme Court also did not say that a more permanent use had to be done over done by a district boundary amendment over a special use permit, special permit. Now, I just want to address something that I heard, at the end of the day yesterday, as well as this morning. Why did I say that this is more of an urban use than an ag use? And the reason why I said that was in looking at the standards in HER 151519, the use, the landfill use, as well as the facilities project, does not fit in with the standards for establishing an agricultural district. So that's why I said that. Now I do want to reiterate what has been stated multiple times, stated as well as in the record. The 22 acres of IAL lands for this project is 22 acres out of the 27,000 acres that EMB designated. Which is also 22 acres out of 235,000 agricultural acres on Maui. In EMB's petition, it stated at the time that the entire petitioned area was used for agricultural purposes, and that is not the case anymore. As you know, in 2016, HCNS shut down sugar, and the majority of land that was once used for sugar cultivation is left fallow. Now, I'm going to just provide you a little bit of commentary. We had a huge fire on Maui yesterday. And as I was driving down Haleakala Highway to come to work yesterday, I could see the fire starting around Hali'imaile. Now, at the end of the long day yesterday, they were reporting that they were getting prepared to evacuate all the way down to Paia and Skill Village. So at the end of the day, they had closed Haleakala Highway down, and ironically, I had to drive home through Pulehu Road. So at first, I believe it was Commissioner Chang who asked the question yesterday, how far is the landfill from any residential area? And I wasn't really thinking about it when I was driving by the residential areas in Kahului, but when I hit the Pu'unene mill, I looked down at my odometer and it said something 81. And then I continued down Hanson Road and then turned right up Pulelehu Road. So once I hit the landfill, it was about 80, I was at about whatever, 83. So that's about 2 miles from the Pu'unene mill. No houses, commercial buildings along the way. Then at the top of the landfill, I looked down again. And from there to the first sign of civilization, it was 5 miles, approximately. I don't have tenths of a mile on my thing. So that was Vodka Farm. A little bit further than that is the goat farm, and a little further than that is the first house that I saw. And so once I hit the first house, that was about 6 miles from the top of the landfill. So I don't want to add anything to the record. I just want to, provide this commentary. The record already says that there's no, residential type uses around the special permit area. Now, I want to point out that I see IAL lands every day as I drive on Haleakala Highway. And yesterday I saw it on Pulelehu Road. And I want to kind of highlight, although you all know already, that we are not asking to use the last 22 acres of IAL land for this project. The IAL, for the most part on Maui, is not being used for agriculture at all. It's weeds, ground cover, dry ground cover that looks like short wheat fields, hence the huge brush fire we had yesterday on Maui. So we're not asking to use the last remaining IAL lands. If we were, I don't even think we would be here today. But there are thousands and thousands of acres of IAL not being used for agricultural purposes at this time. Now I'd like to go back to what we are requesting of you today. The amendment again has 3 components, and I will talk about the expansion 40-acre part last. But the first component is the removal of the remaining portion of parcel 20 from the special permit area. The county does not own it. We don't intend to own it. We have no control over it. And I did not hear any concerns about that yesterday. So we're asking for removal of that, that land from the special permit area. Another component is the time extension to the special permit, which does consist of the working landfill. Now this process and trying to obtain this 4th amendment and time extension actually started 5 years ago. And since the 5 years, we came upon 2018 and we hit the date for expiration of the 3rd amendment. So we asked that the time extension be granted, because essentially if it's not, we have no permit. We're not going to be able to operate the landfill. And as a reminder, the only legal landfill that would be remaining is in Hana. I don't think people will drive out to Hana to dump their waste, but I definitely know Hana doesn't want to accept this side of the island's waste. Now to the component of the amendment that I know is concerning to all of you, which is the 40-acre expansion project, which consists of the 22 acres of IAL. The county does agree and want to take steps to remove the IAL designation from those 22 acres. We agree with the conditions that OP stated in their July 1st, 2020 letter to you. We are okay with that. We agree with it. We fully respect that. And we heard additional conditions offered today by OP. And so we are fully in agreement of OP's conditions. But I want to offer additional conditions for you today for your consideration and to hopefully make this easier for you to approve. The first one is within 1 year of approval of this amendment, the county shall identify county-owned agricultural property of similar and equivalent acreage on Maui and submit a request to have it designated as IAL to compensate for the loss of the 22 acres of IAL associated with these facilities with this new project. The second condition is upon restoration of closed phases of CML, where safe and practicable to do so, and if designated as agriculture still at that time, the county shall seek to make lands available for future appropriate agricultural use in accordance with applicable state and federal guidelines and requirements. That's all I have to say right now.
Basically summed it up.
Okay. We're available for questions.
Thank you very much, DEM. Commissioners, questions for DEM? Commissioner Chang, followed by Commissioner Ohigashi.
Thank you, Mr. Chair. I appreciate the county's additional clarifications and the additional conditions. I guess I would just ask you under your second, upon restoration, if the land is appropriate for ag, then you would seek to make available the appropriate use. What if it's determined that it's not appropriate for ag? What is the county going to do?
You know, I'm not sure. I haven't spoken to my people about that. I envision it to be like an open space if it's not appropriate for agriculture. You know, from what I understand from the engineers is that it really is more of a engineering kind of thing. How can we make it appropriate for agriculture? It's kind of an engineering design thing. But, you know, I can't really talk about, you know, too much about that. I don't know.
Okay, I mean, I do understand it's hard to, it's maybe speculative, because you're asking for an extension until, remind me, what was the date you're asking an extension till?
Just 2028.
2028. And you're confident that's the only extension you need?
Honestly, I was brought in to this case very shortly ago, a couple of weeks. And so if it was my decision from the beginning, you know, I probably would have asked 20 years or at least 10. So, you know,
okay.
I think we would be coming in for another amendment from you folks.
Okay, I appreciate your honesty on that, because yeah, I'm wondering, to put this kind of investment just for another 10 years may not be the most prudent course of action, but I leave that to the county. Sometimes I also believe that it is, if there's intention, if the intention is to restore the site to agricultural uses, then that helps drive some policy decisions about how you know, so it's more than just maybe an engineering or technological, but it may be the intentions of DEM. If it, again, if it is intended to go back to ag, then you will take appropriate actions. But if it's not the intention to go back to ag, and maybe again, this is too speculative, would the county consider at that point in time doing a district boundary amendment?
You know, I do think so, because that, like I said, has been discussed. Should we do that? And so, you know, we're hearing you folks today loud and clear. And with regard to what you said, the intention, you know, we hear you, and maybe if there were no plans to make this restored back to ag, now we're hearing that we should make a plan for what happens after this is all done.
Thank you so very much. Mr. Chair, I have no other questions.
Thank you, Commissioner Chang. Commissioner Ohigashi, followed by Commissioner Giovanni.
Mrs. Chair, am I allowed to ask questions from testimony before?
Yes.
Or only on what was presented today?
Meaning, sorry.
I'm just curious what is the scope of my ability to ask questions, because I wanted to ask some questions about the some figures over here that they had in their, I guess, Exhibit 7.
Yeah, that's fine.
Okay, I'm not sure who can respond to this, but Ms. Wan indicated that you follow the quarry. Okay, so I'm looking at this page number 17. All right, and the Central Maui landfill, that's Exhibit 7, page number 17. Central Maui landfill is right there. I'm looking in the middle of it. And next door to it is the HCND LLC quarry. So is that where the next expansion for the landfill will take place?
I can have a moment. I'm going to have to get one of my people to answer that question.
Hi, Deputy Agawa here.
Mr. Chair, this is Deputy Director Shane Agawa. He hasn't been sworn in yet.
Okay, thank you. Mr. Agawa, do you swear or affirm the testimony you're about to give is the truth?
Yes.
Please proceed with.
To answer the question, the actual next expansion of the Central Maui landfill is currently in the bid process. It's phase 3. That is right adjacent to the existing landfill. But there is some validity to following the quarry, as was mentioned earlier. That would be after phase 3 expansion, would be the next planned expansion to follow the quarry.
So are you guys following the quarry now or not? I'm just curious. The statement was made, that's one.
Currently, we are not. Our plans, yes, is to follow the quarry in the future. The quarry is still active currently, so we cannot assume to take over that land for landfill use at this time.
Can I just ask them, the expansion that you're planning in the future, was that quarry used before?
A different phase of the quarry, yes. Yeah. The completed phase of the quarry, yes. Yeah. It was used, what we are currently landfilling now. Yes.
So could you point out in Exhibit 7, or the number 17 on Exhibit 7, could you tell me what part of the expansion falls within those black lines, the approximate project site location of the landfill?
The black lines meaning the quarry uses.
The landfill itself. I want to know where it's going to go in any of the black line.
Are you talking about this
But phase 3 is outside
slide?
as well, right?
Yeah.
The one with the green showing the IAL?
So none
Right.
of it.
Right.
No, the one in the green, and there's a black line going, says approximate location of project site.
Is it possible to do a share screen on this for the benefit of the commissioners?
I don't have the ability.
No, not Mr. Ohigashi, but DEM.
Right. Is it still left?
Yeah.
We can share the presentation and get to that slide.
Okay, if you can hold on a minute, I have not done this before.
Let's see. Share screen. Exit full screen. Oh yeah, so share screen, sorry. And then that one, yeah. No, just that one, and then share. Just
right here?
Yeah, just good. Just share. It should share your desktop. And then out of that.
It was in my email, but then you set it aside. Wasn't it Adobe? We took it up. And it was Adobe. You got it.
Okay. Let's stop sharing.
If it's too difficult, maybe I can clarify my question.
Where did it go?
So if you're referring to our presentation yesterday that showed a big green area showing the important agricultural land, and
Right.
within what that's on page 17, and you're asking about the black lines showing the location of the project site.
Right.
That is the location of the expansion project. That is not going to be part of the landfill. That is going to be the facilities for the various diversion and recycling operations.
Okay, because I just want to be fair to you guys. That's my problem in this case. None of the landfill operations are taking place on that expansion site. The only operations that are taking place on the expansion site appear to be so-called industrial uses that I cannot find in the record that are tied directly to the landfill site. So I'm having a difficult time saying that a special use permit should cover that 40 acre site, given the fact that the future expansion of the landfill itself is not going to take place on that site. And in fact, the future expansion, which is the HC&D LLC quarry for the landfill, is not on that site. So could you help me out and tell me whether or not a special use permit should be issued or a district boundary amendment should be issued for industrial uses solely for the purpose that hasn't been connected to the landfill at all?
DM?
Can I ask Mr. Roy to answer your question? Or a part of your question?
You can respond.
Thank you, Mr. Chair. Thank you, Commissioner Ohigashi, for the question. As I mentioned yesterday during testimony, this has been quite a process for the county. We've been in this process for about 5 years. There was a dedicated effort at the very outset to coordinate with the state and the county to determine the appropriate process that should be followed for requesting this additional expansion to the Central Maui landfill. During that early consultation process, it was determined that, well, the guidance that was issued was based on the uses being directly related to the existing landfill operation, and the landfill being an identified special use within the agricultural district by county zoning, that it was appropriate for the county to seek amendment to the existing special permit that covers the landfill.
Mr. Higashi?
If that's your answer, there's nothing else I can say, but I've laid out my problem. And I'm sure everybody will decide on their own. But that is my problem. Thank you.
Okay, we have Commissioner Giovanni and Commissioner Okuda. I'm continuing with questions. I will say one thing about this docket. It has been a testimony to my inability to accurately estimate how long we would be spending on it. We are now pushing up. I thought we might be done before lunch yesterday. I don't think we will be done before lunch today. If Mr. Giovanni and Mr. Okuda have brief questions, I would suggest we do them before lunch and then take a break for lunch and then move into deliberation. Is that acceptable?
That's acceptable to Mr. Giovanni. Of course, I never speak for Mr. Okuda.
I just have one question, and it actually is a follow-up to Commissioner Giovanni's statement earlier, so
Okay.
I'm pinning it on him.
Oh, wait. And then Mr. Hopper seems to have raised his hand again.
Sorry, Mr. Chair. I just wanted to offer, if at all possible, a reference in the staff report responding to the commissioner's previous question about the expansion area use. The planning department just had referred me to a part of the staff report that might be helpful.
This is directly responsive to Mr. Ohigashi's recent question.
Yes, I believe so.
Okay, can you be brief, Mr. Hopper, and then we'll go to Commissioner Giovanni, Commissioner Okuda, and unless there's any other commissioners, we will then break with the intention of coming back for deliberation.
Subject to, okay, the page 3 of the staff report that you have as a matter of your record talks about the 40-acre expansion area. It says the DEM proposes an approximately 40-acre expansion to increase the county's integrated solid waste management and recycling / diversion facilities on the Central Maui landfill property, which will serve to reduce the amount of waste entering the landfill. And then it lists the facilities. I think the idea is that this is an accessory use to the landfill and is directly tied to the landfill use. It's part of the same use. So I think that's just what the planning department staff report did address, and wanted to just get that response on record. DEM can correct me if they disagree with this, but it does appear to be part of and integral to the operations of the landfill ongoing.
Thank you, Mr. Hopper. Commissioner Giovanni.
Well, let me start by saying I disagree with Mr. Hopper and his interpretation of what is a landfill or an ancillary requirement to be part of a landfill. And my feelings are more aligned with those of Commissioner Ohigashi. So let me start with a technical question to DEM or your engineering consultants and planning consultants. When you have a process that would take waste and look to divert that waste, reduce that waste, otherwise recycling part of that waste, you end up with a lesser amount of waste that actually has no other outcome other than perhaps landfill. So what I envision in this project is that the original idea for the landfill was purely to take all the waste and just put it there. And now we're diverting part. So in essence, we are expanding the capacity of the existing footprint and buying a lot of time for this facility to accept waste. My question in all of this is to the engineer or planners, is it not possible, feasible, and even common that diversion and recycling facilities are not adjacent to a landfill, even though their end products or part of their end products end up in a landfill?
DM, the question is for you. DM, the question is for you.
Yeah, thank you, Member Giovanni. The answer to your question directly is yes, it does happen outside of the Central Maui landfill location itself. In addition to that, though, you hit the nail on the head. It is directly part of landfilling, what we're proposing on this site. Although it may seem industrial in nature, like Member Ohigashi was saying, it attributes to landfill diversion directly. It does give life to the landfill. Efficiency-wise, having it on site versus having it off-site at a private location, it just makes sense. It's efficient, it's cost efficient as well. But to answer your question directly, yes, it does occur off-site as well on private property.
I would agree with that, and I would also concur with your statement about it might promote efficiency and cost savings to do it adjacent, but it's not necessary to be adjacent. So thank you for that. So then the other kind of related issue I have, and it goes back to kind of Mr. Hopper's opening comments in his testimony a few moments ago, is that this is not a amendment to expand a traditional landfill. It's an amendment to add industrial facilities that would work in concert with the existing landfill and thereby reducing the demand on that existing landfill, not expanding the demand of that existing landfill. If this was purely a amendment, a request for an amendment to make a larger landfill, then I could accept Mr. Hopper's arguments that a modification of the permit made the most sense. But that doesn't seem to be what this is about. I wonder if Mr. Hopper could comment further.
Certainly. I think that a landfill is not only composed of what's in the ground. I think that you've got landfill facilities that oftentimes have structures or other uses, not necessarily exactly like this in other counties. In addition, I don't see how a special permit for the landfill use would be allowed, but a special permit for these uses, which are certainly related to the landfill, would not be allowed by special permit. If you look at the criteria of HRS 205-6 in the Land Use Commission's rules, I think they serve similar purposes to what's allowed than the landfill. So I don't think that if you do anything other than put the garbage into the ground, that's a landfill, but anything else other than that, even if it's related, has to get a district boundary amendment. I think that those uses can still be allowed by special permit. And so I do think that, this is clearly tied to the landfill use. It's not literally the same thing as putting the garbage into the ground, but it's certainly accessory to that use. And I don't see how you would you've got discretion in exercising the criteria of 205-6, but I don't see that as a matter of law, you could not grant a special permit for this use along with the rest of the landfill use.
Thank you for the elaboration. I have no further questions, Chair.
Thank you, Commissioner Giovanni. Commissioner Okuda.
Thank you, Mr. Chair. This can either be answered by Mr. Hopper or DEM or its counsel. Commissioner Giovanni made an observation about the fact that right now there are no neighbors around the proposed facility. Isn't it true that there might be a benefit to the County of Maui by going with a district boundary amendment? Because if that amendment is granted, that settles the issue as far as before the State Land Use Commission about people complaining to the State Land Use Commission that, gee, maybe the use should be stopped. Because once the district boundary amendment is granted, then it's granted. If on the other hand, all you get is a special permit and that permit is subject to a time limit, in the future, your facility, which actually may be and probably will be a benefit to the county, might be subject to challenge. So isn't there really a benefit in the long run and maybe even in the medium run by going for a district boundary amendment, even though that process in the short run may seem to take a little bit more time. And that's my only question, Chair.
So the question was posed to either DEM or Mr. Hopper. I'll allow both to reply.
Yes, thank you, Chair.
Mr. Chair, we totally understand this issue. We acknowledge what Commissioner Okuda just said, as well as Commissioner Giovanni yesterday. And we do acknowledge the importance and the beneficial benefits of having a district boundary amendment. So there will for sure be further discussions on moving towards that direction. We just do hope that this amendment is granted.
Mr. Hopper.
Yes, the only thing I would add to that is that if you do a district boundary amendment and the landfill needs to expand beyond the boundaries of that district boundary, you would still have to go before this commission to get another amendment for that area. So, you know, it's certainly DEM's approach, and they can choose. I think it's certainly a possibility to get a district boundary amendment. It's an option available. But I would note that if the landfill would have to continue to expand, you'd still have the same issue of potential challenges to future urbanization of additional lands if that approach was taken.
Thank you, Mr. Hopper. Commissioner Ohigashi.
Just a comment I wanted to make. I see the benefit in the 40 acres being determined to be by boundary amendment. However, there appears to be nothing in my mind preventing the landfill from continuing and going forward and getting time extensions. The question or the comment I have is that, are we able to sever the issues and grant time extension? And what was the other one now you're asking for? Well, sever the issues and require that the expansion portion come in for a boundary amendment.
I believe that might be a question for council, Mr. Morris.
Or are we stuck with up or down the whole thing?
If Mr. Morris, if you could review for the commission the four large options that we have in front of us, from denial through other options.
Okay, I think we had talked about the granting or the denying or the granting with conditions attached. Mm-hmm. And the fourth option, I'm not sure.
Remand.
Okay.
For further proceedings, since we are limited to the record at hand. So the question from Commissioner Ohigashi is it possible to approve in part?
Well, I don't think that's in one of the four categories, but if approving in part was construed as we're approving it, but we're attaching conditions, that's sort of like approving in part. So I guess you'd have to be real specific about what part you're not approving and how you're addressing that.
Well, let me put the question simply. Can we approve the extensions of time as well as the other? I'm getting a blank right now of the other request, but deny expansion?
I don't believe so.
So it's either all or nothing.
Or remand or attach conditions.
Okay. Mr. Morris, Commissioner Okuda, I do want to take a break soon for lunch. Commissioner Okuda.
Yes, Mr. Chair, I would request that if that is the Deputy Attorney General's advice, if he can reconsider that and provide authority that so states, because I believe we can grant in part and deny in part. I don't see anything in the rules or the statute as long as we don't violate something else. So I only make a request that, because that's an important question that Commissioner Ohigashi has raised, that the Deputy Attorney General over the lunch break look for authority that supports that and maybe reconsider his advice. Thank you, Chair.
Thank you.
I will do that.
Thank you, Mr. Morris. The last question I have is actually for the Deputy Attorney General. And let me see if I can phrase this correctly and recall exactly what I want to say is, no, I'm sorry. I lost it. It was a procedural question. I apologize. Commissioner Giovanni?
Thank you, Chair. I think I have a quick question. So DEM has maintained that time is of the essence, that they've been at this process for 5 years and they want to move forward. And I appreciate that fully. So if the question is, if we approve the request, whether it has conditions or not, when would the development work, shovel in the ground intent, when do it start on the 40 acres?
Sorry, if I can just have a moment.
That the statute. Chair. Specific approve, deny. Chair, this is Commissioner Wong.
Commissioner Wong.
If DEM needs more time, plus our AG needs more time, can we take a lunch break and get back?
We will. I remembered my question. I just want to confirm with our Attorney General that we were given orally by DEM some conditions they would be willing to accept. I think it would assist the Commission greatly in their deliberations to have these in written form in front of us. Is it violative of any of our processes that those could be shared with us prior to our deliberations, as long as they're shared with OP and the county?
Well, I think if they're just going to be putting in writing what they've said orally in their testimony here, I don't see why that's a problem as long as you say it's shared for any members that are viewing it and wanting to participate or review it.
So I would ask the council for DEM to work with Mr. Hakoda and Mr. Oradenker to share what you orally had shared as proposed conditions and get those to the commissioners and the parties over the lunch break as well. Is that possible? I see you nodding. Can you, for the oral record, say yes or no?
Yes, it is.
Thank you. Okay. Is there anything further right now, commissioners?
Mr. Chair.
Commissioner Giovanni and then Commissioner Chang.
Well, I'm waiting for an answer to my question about a shovel in the ground.
Got it.
Yes, 2022. So shovel in the ground as early as fiscal year 22.
Sorry, please identify yourself for the record.
Oh, Deputy Director of DEM, Shane Agawa.
Thank you.
So to answer Commissioner Giovanni's question, as early as fiscal year 22.
Does that answer your question, Commissioner Giovanni?
I just want to be sure. So you would do physical work on the property starting 2 years from now?
Correct.
Thank you.
Commissioner Chang.
Thank you, Mr. Chair. Since we're going to ask DEM and our AG to do some work during lunch, I guess for me, the question I have for DEM is, is their application, the 3 points that they asked, one, the removal, the time extension, and then the expansion, are those, from a management standpoint, can they indeed separate them? Because I agree with our Deputy AG. I don't believe that we can bifurcate, but that's what they're going to look at. because I think we have to look at the application that's before us. But I would like to know from a practical matter, whether this county can indeed do what we are asking them. That's so while they're lunch break, that's the question.
So thank you for that, Commissioner Chang. What I would like to suggest is that I will then, after lunch, we will recess, reconvene at 1 p.m. I will give the briefest of opportunities for DEM to respond to that particular question. And then I believe that we are probably ready to go into deliberation on this matter. Is that acceptable, commissioners?
Yeah, guys, send it to me.
Mr. Chair.
Mr. Ordenker.
Could you have, could the county please send their email with their proposed additional conditions to Scott Derrickson? Riley and I have another matter we have to address during lunch.
Okay. I apologize for that. You can do that, DM? Yes. Okay. It's 12:17. We're going to reconvene at 1 p.m. for deliberations after hearing briefly a response to Commissioner Chang's question. Wong, Okuda, and Cabral, and myself, Alhigashi, Axon, Giovanni, and Chang. We have all 8 of us. We need the parties. And just confirming the presence of our court reporter.
I'm here.
Thank you, Jean.
You're welcome.
OP, you're with us. Perhaps Maui County have decided just not to show up. They're done.
Sorry, we're here.
It was a joke.
Sorry.
Mr. Hopper.
So, yeah.
Aloha.
Sorry.
I thought they were with Dr. Fauci.
Okay. I'm going to call us back into order. It's 1:03 p.m. Friends and colleagues. There was a request for a response to a specific question from Commissioner Chang to DEM prior to the break, and then I indicated that we would head into deliberations. DEM?
Can you please repeat the question?
Okay, thank you. This is Commissioner Chang. The question I asked, based upon the previous conversation, was could we bifurcate? Could we not? So the question I have for DEM is, you came in with an application asking for three actions be taken. I want to know from DEM, is that necessary that all of these 3 parts be approved, or can we separate as being discussed?
Thank you. You know, as far as I'm concerned, without the granting of the time extension, we have no landfill as soon as you deny it. So if Mr. Morris says that you can deny it, grant it, or grant it with conditions or remand, without the granting part or denying part, if you were to deny it, then we don't have a Central Maui landfill after that. I do want to turn this over to the DEM deputy director or the director, because if the 40-acre expansion project is denied, there are some repercussions. So I just want you folks to hear from them what their situation will be.
Okay.
Go ahead. Sorry, Commissioner Axon?
Mr. Chair, is it possible to hear our deputy AG first on his opinion before we go?
Regarding the bifurcate, the denial in part?
Correct.
Okay. Yeah, no, that might make sense. Mr. Morris.
Yes, thank you. you know, I've had a relatively brief period of time to review this question, but I'm looking at Administrative Rules 151595, 151596, and 151596.1. Because this project is greater than 15 acres, the county's role is primary here. And in those administrative rules, it lays out these four options: grant, deny, remand, or place conditions. And my reading of the conditions would be additional requirements. It says that the commission in 151596, the commission may impose additional restrictions as may be necessary. I do not see that as the same thing as saying, well, we will allow an extension of time, but deny the expanded footprint. I don't see that as an additional condition. So my inclination under this scenario is to say that if they wanted to suggest, well, we'll grant the extension of time, but we're not going to let the application or this petition include, we're going to deny the part about an expanded footprint, I believe that will require a remand to the county for their consideration of the changed request. It really wouldn't be the same special permit that was approved by the county. So that's my view, is that I don't think you can grant in part and deny in part in the way that we've talked about without some attendant remand to the county.
Thank you, Mr. Morris, for that. Was that responsive, Mr. Axon?
Yes, thank you, Mr. Morris. The other question I have is for, I guess, our administrative staff on how long it's gonna take. If you do remand this, how long it's gonna take, some kind of a timeline, and how long it's gonna take to get this thing done. Because I'm more concerned about not having a landfill. That's my only concern. So I just wanna kind of see how long it's gonna take, because we don't want the county operating illegally on this one, whether it's 1 month, 2 months, 3 months. We don't want any illegal operations. And this thing went, 5 years already. So every day that they do illegal operations is not a good thing.
Commissioner Axon, we will, if the decision is to remand back to the county, we'll transmit that to the county immediately. The difficulty is when the county wants to hear it, how they can, and when they can render a decision. The minimum on this would be, because they have to hold a hearing, render a decision, and then adopt the minutes and everything to send them up to us. The minimum is 2 to 3 months. If they have a lot of if they're busy, it could take a year.
Yeah, procedurally, this one's gonna go back to the planning commission and then the county council.
Yeah. No, it goes back to the planning commission. But
and doesn't have to need approval from the county council.
No, it does not. But for us to act, they have to transmit the entire record to us, which takes some time after they render the decision. That's why I'm saying, if they heard it next, it would take 3 months.
But if I may clarify as chair, one part of Commissioner Axon's question, and this might be directed towards Mr. Morris or Mr. Oradenker. Only a denial would result in the county currently operating without a permit, because under the appropriate rules, it is my understanding that so long as they have a pending application for an extension of their permit, they can continue to operate even if that permit has passed its expiration date.
I got nothing. I'm not sure what the answer is on that.
Yeah,
Commissioner Cabral,
I don't know the
I see
answer.
that your hand and other hands.
Okay.
No, Commissioner Cabral, hold on. I was just saying you were waving your hand. I was acknowledging that I've noticed that you're in line to speak. Mr. Morris?
Yeah, I don't have an answer for you on that, whether the pending application, if they were to be issue a new request for additional time, if during the pendency of that, it would be fine for them to operate. I don't know the answer to that. I can work on it, but I don't know.
Okay. Thank you. Mr. Axon, anything further?
That's all, Mr. Chair. Thank you.
Okay, so we were planning to go to DEM's response, but I have hands up from Commissioners Ohigashi, Cabral, and Chang. So we'll do those first. Ohigashi, Commissioner Ohigashi.
I just want to caution the county DEM about additional evidence that is not on the record. If they intend to place into the record things that were not discussed below or not contained within the record, because apparently I'm not sure if I don't believe that we can consider that. Is that right, Mr. Mark?
Well, I'm confident saying that we're confined to the record before us that was sent up from the county proceedings.
Okay. Commissioner Cabral.
Can't we just hear them?
Thank you. I wanted to speak up, not necessarily in disagreement, but somewhat in disagreement with my other fellow neighbor island, Better Island commissioners. I think that I keep hearing the theme of a landfill is not a landfill because it has a warehouse and it does recycling or something. Right. And it's, in a sense,
Commissioner, are we in deliberation now, or do you have a question for Mr. Morris?
I guess my question would be, is there a legal definition under which this has been brought forth that a landfill is restricted to only putting stuff in the ground as opposed to a recycle and rubbish facility?
Okay, that would be a question actually under the Maui County Code. I'm going to hand it to Mr. Hopper to respond to, and then Commissioner Chang.
Okay.
You're asking what the definition of a landfill is under the county zoning ordinance?
Well, my question is, I'm getting this that a landfill can only be something because it's where we fill the land with rubbish. Where in fact, I feel like a modern landfill could be on that IAL land, have the piggery, you drop off your slop, you go through the building, you drop off your plastics, and you're really into a recycling. And I mean, and the new world is no longer a landfill like it was 20, 50 years ago. It is really a recycling and reuse and final waste site. And I think we're getting hooked up on what we think is a landfill, and if the application of a landfill is restricted to just a hole in the ground, then we have a problem. But otherwise, if it's the bigger definition, then everything that you're proposing should be acceptable on the expanded land.
I'm looking just in Title 19 of the county code, which deals with zoning, but there's not a definition in the zoning ordinance of just landfill. There might be another definition where it would fall under. Of course, that goes into what's allowed in county zoning. I think in this case, under HRS 205 in the Ag District, as the AG talked about, as OP talked about, there's not a definition in HRS 205 of what a landfill is. So we acknowledge it's not one of the listed permitted uses. So whatever is being done is something that's for which a special permit is required because it's an unusual and reasonable use. Maybe there is a more industry specific definition of what a typical landfill would include. I just checked the county code for the zoning area and don't see a definition of landfill. I could look more in depth, but maybe DEM could help with explaining that a typical landfill could include additional things other than just what's in the ground. But for the purpose, I think, of the special permit, the issue is whatever you're being asked to allow, is it consistent with HRS 205-6 and the Land Use Commission's admin rules? And again, that analysis is here, and the focus on that for however the use, whatever the use is defined as, that has to meet the requirement of 205-6 as an unusual and reasonable use.
Thank you, Mr. Hopper.
Yeah, sorry.
Commissioner Chang, you've been very patient.
Thank you. I would just like to ask to provide DEM the opportunity to complete answering my question.
Yeah. The question again, DEM, was what the practical effect was on whether these could be split, I believe, to paraphrase your question, Commissioner
Well,
Chang.
no, and I believe they were just about to bring up their administrator, who's going to talk about what the consequences of not the expansion, and then we took other questions. So I'd like DEM the opportunity to complete their answer.
Yes.
Thank you.
So Deputy Agawa here again. Yeah, so regarding if we don't get approval of this amendment regarding the Central Maui landfill capacity, the current working landfill, the working phase of the landfill, we're looking at about another year and a half of airspace. As I mentioned earlier, we do have a Central Maui landfill phase 3 expansion that's going on. That'll buy us another 4 years, roughly, approximate. And this is assuming that the project we're bidding out now, but that's assuming there's no hiccups in the project, no hiccups in construction, you know, everything goes on plan. So we're looking at another 5.5 years from today for capacity. So we'll probably reach capacity in about the year 2025, 26. And then we'll be in dire straits. We're either gonna be denying people throwing rubbish in the landfill or be operating against DOH regulations.
And that was all part of your record. Is that in going back to Commissioner Ohigashi's admonition about making sure that what you're saying is also part of the record?
So there are multiple places in the record that has that 2026 date of the capacity of the landfill, that if we don't have this diversion project, there's multiple places. With regard to, you know, if the commission wants us to instead get a district boundary amendment, you know, that of course is not in the record because that wasn't, you know, a question before us. But from what I understand from Mr. Roy, you know, that could take 5 years. We're gonna have to hire outside counsel, do various requirements. And so that, you know, we're in 2020 right now, that'll bring us up to 2025. So that's in the same range year of when the capacity of the landfill is going to be, you know, dead, exhausted. Mr. Roy, do you have anything?
I can, Mark Roy with Unicare Haraga, I can just add to the comments about the DBA process. And it's just an important, I think, piece of additional information that with a district boundary amendment, the county would also need to go through equivalent community plan amendment and change in zoning processes. They would also need to amend the Maui Island Plan, which is a general plan document for the island. And as Mike Hopper mentioned earlier, those are highly discretionary processes that involve approvals, of course, before the Land Use Commission, but also the Maui County Council and the Maui Planning Commission. And so we can easily estimate at, you know, about 5 years, but there's no real knowledge as to how long that process would take. It's definitely known that it's a very expensive process for the county to entertain, but highly discretionary, and you know.
Excuse me, I'm sorry. You were probably, I probably was not as articulate with my question as I should have been. It was a very, very limiting question. You came in with an application that came before the Planning Commission on 3 requests. It was to take out the 22, it was to extend, and it was extend the duration and then expand. That was your application. My only question was, could we take any, because there was a discussion about bifurcation. So I just wanted a confirmation from DEM that your application that you presented to the Planning Commission, all of those 3 elements were critical to proceed forward, that we couldn't take out 1 and then do 2 of the 3. So that's the only thing I wanted, was a confirmation that the application and the presentation to the Planning Commission was that all 3 of your requests are dependent upon one another and critical to moving forward. I'm seeing a nod from the administrator. Is that correct?
DM?
Yeah, not a hard question.
So to answer your question, Commissioner Chang, you know, the time extension is really the most critical. We need that, we needed that time extension granted in 2018. The parcel 20, that is, not critical, removal of the parcel 20, but the expansion of the project, it's not critical today. It will be critical in 2006.
All right, thank you very much. And I think our Deputy AG also answered my question by saying we have to consider what was before the Planning Commission and we can't piecemeal it. So thank you very much. I have no further questions, Mr. Chair.
Thank you very much, Commissioner Chang. And my decision to allow the AG to speak and hold DM in abeyance was at what I took to be a very good suggestion from Commissioner Axon, that we hear from our AG on his thoughts prior to their response. Commissioners, during a difficult time in the world, we are faced with making a decision on a very complex issue. I believe we could certainly find ways, interesting ways, to go on with additional questioning of all the parties. But I think we're at the point, my sense is that we could move more productively into deliberation. During deliberation, the only participation from other parties would be to answer very narrowly tailored questions from commissioners to a specific party at my discretion. Are we prepared to go into deliberation? Yeah, okay. So we are in deliberation on this docket, and perhaps the best way to move into deliberation is if somebody wishes to offer a motion.
Chair, can I ask, before we go into deliberation, I need some legal advice. I don't want to go to executive session, so I wanted just to ask the AG. 2 parts, 2 questions. One is, hypothetically, first off, you said we cannot break in part the whole thing, but hypothetically, can Maui DEM stipulate, take out one portion? Is that allowable?
Well, again, I think if the request for a special permit morphs into a different request with different components that the county hasn't considered, that's going too far. Now, I want to also point out that the statute talks about the commission being able to take representations from the petitioner and have them adhere to it. So we've had some proposed things that, well, we'll do this in a year, or we'll do these various additional things, these additional requirements, fine. But to sort of modify what the scope of the permit is with these 3 substantive areas getting narrowed down to 2 or just 1, I don't think the county has had a fair chance to weigh in on that.
Okay, so the other hypothetical question I have is, again, there's a portion yes and no. Can we say yes to 2 parts and then remand back 1 part?
I believe if it's a remand, it's a remand. I don't think you can piecemeal it like that.
Okay. Thank you. Thank you, Chair.
Okay. We are in deliberation.
Chair, do we need a motion to start deliberation or can we just deliberate?
We can go for some period without a motion before us.
Chair, I'm, you know, I'm going to tell you the truth. I'm in a quandary right now. From my last questioning with the AG, that I understand there's an issue. The time extension is really needed. Expansion is, yeah, okay, you know, and then we have that last part that. So I'm in that quandary is, how do we, you know, I want to share the pie pretty much that, and I'm trying to figure out ways to go around it, like putting a condition or something. And I just need, I don't know how to do it, Chair. That's, or how to even make a motion. So if someone.
Thank you. Commissioner Ohigashi, followed by Commissioner Axon.
I don't have an answer for you, Mr. Wong, but I do have a comment. This is the first time during these proceedings that I've heard DEM indicate what consequences may happen. I've looked at the record and I've tried to find comments in the record. Counsel for DEM is correct. That they mentioned that they would achieve capacity at being 2026. And they testified to that. But nowhere was there attached that this particular section, this particular area, which is the 40 acres, is a requirement, was required to make sure that they are good beyond 2026. The second thing is that the way I look at it is that at any time, they could have come forward with an extension of time. It's a simple motion. All they had to do was say, hey, we need some extensions of time here because our permit is running out. And the commission, Planning Commission, and the commission, the Land Use Commission would probably go ahead and grant them that time. They could have come at any time to remove that section, that 16 acre, 17 acre section, and that would be not a substantive. But they chose to package it all together with a 40 acre industrial park, for lack of better words. It's a 40 acre industrial park. It has office of 8,000 square feet. It has an abandoned vehicles area, 2 acres. It has metals processing area, 40,000 square feet, which is an acre almost. Open construction, demolition, material recovery area. Household hazards waste, electronic waste and storage area. Warehouse and storage area. Refuse collection office, truck parking, maintenance area, drainage basins. Wailuku Industrial Park would fit this bill. So rather than being in a quandary, I would remand with instructions to them saying, show on the record where this is necessary for the purposes of extending the life of the landfill, and if so, come back with a boundary amendment and remand with instructions that they can come back with an extension of time and to remove the 17 acres. I hate to point fingers at the county, but it seems to me that they're bootstrapping the good stuff with the bad stuff, or not the bad stuff, but the things that require us to take a look at it in more granular fashion to make that determination. But that's my position. And if they want on remand, if they feel that they want to put in that the record to indicate that this is such necessary to extend the life of the landfill and all of that things and bring it back up as a special use permit, my suggestion is that they would bring it back up separately and bring up the other two issues separate from this one. And we can have a discussion on that. That's all I got to say. That's going to be my position in this matter.
Thank you, Commissioner Ohigashi. Commissioner Axon.
I'm not sure of where we are. Are we in deliberation or something else? It seems like we are in deliberation right now.
We are in deliberation, but we have not yet had a motion put before us.
Yeah, so I guess my thing is I can understand everybody's frustrations, and I wish we're in a different situation than this, but you know what we have is what we have in front of us, and we only have 4 options to do it. We can jump, scream, and everything that everything is not okay, but by the end of the day, we are supposed to make a decision based on the options that we are allowed to do. So that's only my comment, and I don't know if that's part of the deliberation or not. Thank you, Mr. Chair.
Thank you, Commissioner Axon. So commissioners, it will guide us if somebody wishes to make a motion. Obviously, if somebody makes a motion and the motion fails, it means that an alternative motion will have to be made by somebody who is on the winning side of that. So for instance, if somebody was to make a motion to grant without conditions the special use permit, and that permit vote failed to get 5 votes, then somebody who did not vote for that motion would then be the next to make a motion. Commissioner Cabral.
I would make a motion to grant them their request with the 2 conditions that they've provided, that within 1 year of approval of this amendment, the county shall identify county-owned agriculture property of similar land properties in equivalent acreage on Maui and submit a request to have it designated as IAL to compensate for the loss of the 22 acres of IAL land associated with this facility project. And number 2, that upon restoration of closed phases of the CML and where safe and practicable to do so, and if still designated as agriculture at the time, the county shall seek to make such land available for future appropriate agriculture use in accordance with applicable state and federal guidelines and requirements. Thank you.
Thank you, Commissioner Cabral. A motion has been made by Commissioner Cabral to grant the special use permit as previously passed by the Maui County Planning Commission with the 2 additional conditions offered by DEM. Is there a second? Commissioner Axon.
Yeah, I would like to second that. Since
Okay,
nobody
we have a successful motion in front of us
just
to
wanna
grant the permit. Sorry, Commissioner.
just for the sake of discussion, I want to second that.
Okay, so we have a motion in front of us. Who wishes to speak to the motion? Does the move-on wants to speak to it first? And then followed by Commissioner. First, I'll give Nancy an option, then followed by Commissioner Giovanni. Who wishes to speak to your motion?
It's a procedural question. I'd like to propose consideration to Commissioner Cabral to add an amendment to her motion. Should I do that after she speaks for it, or?
Why don't you go ahead and, if you wish to make an amendment to the motion, please offer it now.
I'd like to, I support the motion with an amendment subject to a further condition. So I would like to amend the motion to add a condition in which the petitioner will seek a district boundary amendment from the Land Use Commission within 5 years.
To begin the process, to do their initial filing, or?
To begin the process.
Okay, so there is a proposed amendment to the motion. The movant and the second would have to agree to it. Commissioner Cabral, you agree?
Yes, I would agree to that.
Commissioner Axon.
I'm just kind of thinking about the wording. If it is necessary to go to as for boundary amendment. So I'm not too sure if it is required or not. So I'm just kind of not sure about that. So I would accept if it is seek for boundary amendment if required.
That's not what I'm proposing. I'm proposing they seek it, and the process will determine whether or not it's appropriate or not.
Okay, so the amendment has been clarified. Do you agree or disagree with the amendment, Commissioner Axon?
That's fine with me.
Okay, so we have a successfully modified motion in front of us. It is to approve the special use permit with 3 additional conditions, 2 offered by DEM, and the third to require within 5 years of approval by this commission that a land use district boundary amendment be pursued by DEM before this body. Who wishes to speak to the motion?
Since I added the last condition, let me, if
Go
Commissioner
ahead.
will allow me, I would like to say why I think that's important. Should I?
Please proceed.
So first of all, I am very strongly in favor of this project as it's envisioned by DEM and its consultants and its engineers and its operators. I am very strongly in favor of our counties each moving in the direction of increased diversion and recycling of waste and minimizing what I refer to as a traditional landfill, which is you just put garbage in the ground and cover it up. As such, I think it's time is of the essence to allow this project to move forward. And if not for the fact that there's a lot of confusion about whether it's permanent or not permanent, whether it's better suited for a DBA or an endless series of permit amendments, I think that it's just time is of the essence. So I would prefer that it would be a district boundary amendment today, but practical matters suggest that's just not going to happen because it does take 3 to 5 years to do that whole process. And I don't want to shut down the facility for 3 to 5 years while we pursue that and have it operate illegally. Maui County needs it. And this is a good plan. I'm just concerned that if we commit ourselves to an endless series of permit amendments, as the population grows and as the situation changes, we're going to find ourselves in, or Maui County is going to find themselves in a dilemma that they're going to start running into some resistance one way or another. And I think that to settle that once and for all would be a successful district boundary amendment process, which I would support as well, I think, at this point in time. That's why I added that condition to it.
Thank you, Commissioner Giovanni. Commissioner Chang, followed by Commissioner Axon.
Thank you, Mr. Chair. I greatly appreciate Commissioner Giovanni's explanation, as I think it is very sensible, and I too support the direction that the County of Maui is going. We have had other landfill issues on Oahu and the commission has spoken very strongly about the DBA. So while this may be appropriate for special use permit, I think the fact that the county of Maui has been having very serious and discussions about the DBA only reaffirms that I think we're all thinking the same things. So I appreciate Commissioner Giovanni's, his amendment permits the landfill and the county to move forward, but it also provides them direction rather than worrying about what's the intention. It's very clear, but I think it is more efficient what the county of Maui is suggesting, putting everything in the same place. It makes a total amount of sense. But then there is some predictability for the community that through the DBA, a lot of the kinds of questions we may be struggling with will be fully vetted through that process. So it does appear to be sort of, I don't know if the best of both worlds, but I am inclined to support this amended motion based upon that clarification. So thank you very much.
Thank you, Commissioner Chang. Commissioner Axon.
Thank you, Mr. Chair. I also plan to vote for the motion. In my mind, DM has adequately met the guidelines for an amendment to the special permit. I also understand that there's some concerns and about this, and denying this motion. Unfortunately, we only have certain options, and by denying this special permit, it would create some health and safety issues for the community. Having said that, I believe that there are several conditions attached to this motion that hopefully will alleviate some of the concerns until, like Commissioner Giovanni's motion to submit for a DBA within 5 years, and I hope that alleviate more of the some of the concerns. So I will be voting for this motion, Mr. Chair.
Thank you. I'm going to note for perhaps seeking some clarification from our executive officer, Mr. Orodenker, but at this point, the motion before us does not include the proposed language from OP, also requiring within 12 months addressing of the IAL designation issue. Is that correct, Mr. Orodenker?
That's correct, Mr. Chair.
Okay, so I'm just flagging for commissioners that the motion before us, which has been amended once, does not include that proposed language from OP. We're in deliberation.
Chair.
Commissioner Wong. Commissioner Wong.
For what area we're talking about?
For the 22 acres of important agricultural lands, which is part of the subject special use permit. And I will allow on this narrow point for OP to restate what their proposed amendment would be. Condition, excuse me. Commissioner, Ms. Apuna.
Yes, Chair.
Would you restate what your proposed condition was regarding important agricultural lands?
Okay, actually, we proposed two different conditions, but the first one is with regard to the IAL. That petitioner shall submit a petition for declaratory ruling to the Land Use Commission to withdraw the 22 acres of important ag land from the important ag land designation within 1 year of the Land Use Commission's decision and order for this special permit.
Okay.
So that's the first one. Did you want me to read the second one?
Go ahead.
So the second proposed condition, petitioner shall instruct the construction employees during the pre-construction meeting or similar circumstance of the possibility of discovering funerary objects and burials during construction. Further, should burials be found, the petitioner shall consult with the State Historic Preservation Division and cultural and lineal descendants of the area to develop a reinterment plan and cultural preservation plan for proper cultural protocol, curation, and long-term maintenance.
Thank you, Ms. Apuna. So just clarifying for the commission that those were two proposed conditions from OPE that are in the record before us, but they have not been incorporated into the motion. Commissioner Ohigashi, followed by Cabral.
Obviously, I'm speaking against this motion. It's a simple reason why. I'm kind of guided by what I believe the law is. And as I reviewed this matter, it became apparent to me that what we're trying to do is utilize an amendment process for existing special permit to create a new project on land. The amendment process, even if we are saying that, yes, it should be a special use permit, the special use permit process should focus in on what the new use was. It should also include what I believe is a finding as to whether or not it should be better handled as a DBA, a district boundary amendment. I believe that analysis hasn't been done. As I take a look at this, again, what we are trying to do is create, or what is the county is trying to do is create a 40-acre industrial park. It is not an accessory use at this point. It hasn't been supported in any of the documents. What they're trying to do is create an industrial park, which I don't say they can't, but they should follow the requirements of the district boundary amendment by granting them a special use permit. What we're saying is we're going to grant, what technically we're saying is we're guaranteeing a district boundary amendment in this matter. Similar, I guess, to the Mauna Kea case, which granted them a use permit, but held a contested case later. The second part that really bothers me is that if they were planning on this 5 years ago, why didn't they come up 5 years ago, or why didn't they come up when it was ready and done and ask for a declaratory order or declaratory relief as to why or whether or not this constitutes a special permit? We require these types of things from every developer. We scrutinize every developer in terms of what they are trying to do. We make them go through all the paces. But for this purpose, the County of Maui has decided to try and leverage an existing permit and amend it for that purposes. I don't know. I think they gambled, and my position is if they gambled, then they should have backed the record up with significant evidence to show how this is crucial to the landfill operations, and not come in at the last minute and say that this is crucial to landfill operations. So for all intents and purposes, I believe that a remand is necessary, but I will go along with the commission.
Thank you, Commissioner Ohigashi. I have Commissioners Cabral, followed by Giovanni and Okuda. Commissioner Cabral.
I would like to amend my motion to read that as OP has stated, and take their wording would be fine with me, that that they would withdraw their IAL lands, or make the application to withdraw their IAL lands within 1 year. And the second one, that would be that if any type of burial sites are discovered, that they would be reported and dealt with. And again, the wording from OP would be acceptable to me. Although I would have assumed burial grounds or burial sightings was already a requirement, but we'll
Okay,
state it
so,
again. Thank you.
so I'm not enough of an expert in Robert's rules to know if a move on amending their motion is normally allowed, but we'll just say it is. Does so the amended motion would have now 5 conditions. The 2 conditions proposed by DEM, the 1 condition proposed by Commissioner Giovanni, and the 2 conditions proposed by OP. Does the seconder agree?
Mr. Chair, actually, I misunderstood the first motion. I thought was DEM's condition is in addition to OP's conditions. Okay. So I'm fully in agreement with the motion.
You agree with what you thought you had already agreed to?
That's correct.
Okay. So, folks, we have an amended motion with 5 conditions before us. Commissioner, you had nothing further, Commissioner Cabral?
No,
okay, Commissioner.
I agree with Commissioner Exxon. I had thought that too, that the First Amendment, they're going to replace that land, but it did not ever say they were going to withdraw it. So
got it.
The better wording would have covered both, but we're good to go as far as I'm concerned. Thank you.
Commissioner Giovanni, followed by Commissioner Okuda.
Yeah, I concur with the motion 5 conditions as you just summarized. No further comment.
Thank you. Commissioner Okuda.
Thank you, Mr. Chair. I think what Commissioner Giovanni stated makes a lot of sense as far as public policy and planning moving forward. This is my concern because we don't really act as a legislature here. We're supposed to be quasi-judicial, and as much as we might not like the laws and procedures that have been passed, that's what we're charged with following. I'll tell you what kind of, and I think the proper word would be upsetting about this case. And it's not necessarily just directed at the county of Maui, because we see this from other government agencies sometimes. I agree with Commissioner Ohigashi that, we hold private developers to a certain standard, but sometimes when the government agencies come in front of us, it's like, well, we didn't really do all the things which a careful developer does, but please look the other way because we didn't think about this, or we didn't review these precedents. And by the way, the Waianae Neighborhood Board case is back in the 80s, so it's not a Hawaii Supreme Court case which is some type of secret or anything like that. But then we're placed with these situations where we're faced with not only what I would think is a good project, but also a project which might have need in the community. But then we're basically argued to or told, we'll look the other way on violations of process or procedure because the end result justifies the frankly sloppy way we went about this. I believe the presentations, and especially in response to the questions that Commissioner Ohigashi raised, is that there's a serious issue here regarding important agricultural lands. And I think we have to look at what the state constitution says. That's Article 11, Section 3. I mean, this is the overriding public policy which is in the Constitution from 1978. And it says, the state shall conserve and protect agricultural lands, promote diversified agriculture, increase agricultural self-sufficiency, and assure the availability of agriculturally suitable lands. The legislature shall provide standards and criteria to accomplish the foregoing. And then in the Constitution, which is followed up with the statute, there's a section that deals with important agricultural lands. And what does the Constitution say? The Constitution says lands identified by the state as important agricultural lands needed to fulfill the purposes above shall not be reclassified by the state or rezoned by its political subdivisions without meeting the standards and criteria established by the legislature and approved by 2/3 vote of the body responsible for the reclassification or rezoning action. So in other words, that's the mandate that's spelled out by the Constitution, which is also spelled out or laid out by the section of the law. And the testimony has been, the record has shown, this is prime ag. Now, I'm not saying, you know, leave it that way forever, because yeah, it's true. The record shows agriculture has changed, but clearly the process of taking important agricultural lands out of the designation is not being followed. Yeah, perhaps IAL designation is simply a planning tool, but if it's really something that we should and need as a government to pay attention to, then we really need to follow the process. If it's simply going to be something like, oh, no big deal, then from now on, when these petitions come before the Land Use Commission, we really shouldn't spend that much time evaluating it, because it's really not a big deal. But I think the Constitution makes it clear it is a big deal. And the Waianae Neighborhood Board case makes clear too, you can't do a district boundary amendment through a special permit. And if the county had been previously considering doing a district boundary amendment, then I understand in the past, shortcuts have been taken. I understand in the past, perhaps the Land Use Commission had never had a reputation of enforcing the law sometimes. But that really is not an excuse for us not to enforce the law at this point in time. I agree with Commissioner Ohigashi. What we have here is an urban industrial park. That's what we have. I think it's a good project from what I can tell in the record, but it is what it is. And I don't believe that the special permit complies with the black letter of the law, and definitely it does not comply with the constitutional statements of what the accepted public policy is in this community. So at this point in time, I'll be voting against the motion, but I'm willing to listen to what anybody else has to say about this. Again, I understand it may ultimately be a good project based on the record, but what do we do about this continued behavior by, and I'm not just saying the County of Maui, but many government agencies, simply to look the other way, and sometimes you could conclude, ignore what the law says. What do we do about that? Thank you, Chair. I have nothing further to say.
Thank you, Commissioner Okuda. Commissioner Axon.
Thank you, Mr. Chair. I just want to comment that, you know, I really do appreciate Commissioner Ogas's comments, and also Commissioner Okuda. And just for the record that, you know, I just want to put on record that I fully agree with those comments. With the exception of opposing the motion, I fully agree with their comments. Thank you.
Thank you, Commissioner Axon. Commissioners, I believe we have heard from all the commissioners. Commissioner Wong, do you want another statement on the matter on this point?
Nah, that's okay, Chair.
Okay, Commissioner Cabral.
I wanted to also follow up and thank that, in a sense, opposing opinion, because in the big picture, I absolutely see that. And I think we often feel like we need another category of zoning or something that is the middle in between, because it clearly, we don't want a quote landfill in the middle of an urban zoning area with neighbors and businesses all around. And yet we're not looking to necessarily make the middle of the agriculture area urban in order to have what I would call a recycle and refuge facility. So I think the lack of the big picture being in a better condition is forced sort of everybody into the middle of this. And I do agree that I probably feel like that the need of society is forcing me into a position. So I am in favor, but I can appreciate the need to have more options. Thank you.
Commissioners Chang and Giovanni, and then I would like to share my thoughts as well. Commissioner Chang.
Thank you, Mr. Chair. I guess this is maybe in response to Commissioner Okuda's concerns, and maybe it's because I worked in government before, but I think that the County of Maui was operating the landfill historically like all the other landfills. The landfills were done by special use permit. Was that the right mechanism to do? In hindsight, maybe not. But I don't think that they were trying to do something totally extraordinary from the past practice of all of the other counties and landfills. So I guess I'm not as offended by the County of Maui's actions in this respect. I do believe that the county has heard the commission's concerns, and they have expressed that they are going to look for 22 acres to replace the 22 acres that they'll take out of IAL and put that back into IAL. So in other words, to make the IAL lands whole. Quite frankly, right now, when I look at those lands, I don't think that they're IAL. They're currently being used for the landfill. So I would rather them look at true ag land that can be used for IAL. So in my view, I think there is a remedy to address, an appropriate remedy to address the concern raised by Commissioner Okuda, that the county is going to look for replacement ag land that they will put into IAL. It's not a condition, but I'm going to, that's their intention. With respect to Commissioner Ohigashi, and you know, I always give such great deference to those of you who live on the island where the project is being considered, because you know this community better than anybody else. Again, I guess in relationship to Commissioner Ohigashi, I believe that Commissioner Giovanni's amendment to require them to file a DBA is consistent. There's no guarantee that they will get it, but they're going to go through that process. So to me, there is a remedy to begin to start changing the trajectory of saying SUPs are the way to go. I think this commission has spoke very clearly, consistently with the other landfill project on Oahu, that those are better uses in a DBA, not in ag land through an SUP. So in my view, the actions taken by this commission in relationship to one, Commissioner Giovanni's amendment and the county's own intention, I am comfortable that those actions will remedy some of the concerns that have been raised by Commissioner Okuda and Commissioner Ohigashi. So again, I am inclined, I will be supporting the amended motion. Thank you.
Thank you, Commissioner Chang. Commissioner Giovanni.
Thank you, Chair. You all know that I am not an attorney. I am not well versed in the law and the Constitution and the legal record within Hawaii. And I have nothing but respect for those who are, and in particular to my two commissioners who have raised very legitimate, valid, and important issues, Commissioner Ohigashi and Commissioner Okuda, very sensitive to your feelings, and then comes across to me as a personal frustration of my own, because I really feel that what's happening here is kind of a process by which the county, even though they considered a DBA previously to submitting this request for an amendment to the permit, for whatever reason, they rejected it and went the permit route anyway. And I concur with the admonishment that has been offered by Commissioner Okuda for their process and their logic and their determination to proceed as they've done. But at the end of the day, I agree with kind of what was summarized just now by Commissioner Chang, in that it doesn't, what's on the before us now in terms of a motion and 5 conditions does not make all the wrong right, does not correct all the problems of history, but as a practical matter, it's in the public interest of the people of Maui, none of which showed up to oppose this project. I support going forward with the motion and its amendments.
Thank you, Commissioner Giovanni. If there's nothing further, I would like to say a few words as to how I am thinking about this. I'll begin by noting, because it requires noting, we're just living in extraordinary and difficult times. And I really want to make it clear to all of the participants in this proceeding, my fellow commissioners, the staff, those folks on Maui bringing this forward, that none of our deliberations are made to increase your suffering in any way during what is already sort of unprecedented in our lifetimes, ridiculous, difficult times we're doing. Instead, we're actually just trying our best to do the jobs that we committed to do despite the difficult times that we're going through. So I hope you understand that we're sympathetic to the times that we're living in. We're trying to be consistent with our duties, yet not be tone deaf to what we are going through. My second comment is, and I've raised the question about, do we need 5 votes or 6 votes on this? I think if you follow the Constitution, we need 6 votes. I think if you follow our statute for special permits and our administrative rules, we need 5. I think the jury is out, and that unless this gets litigated, it won't be resolved. Though I think very clearly a vote for this motion, which would make IAL into something other than IAL by practical effect, would seem to indicate that you should be having a 2/3 vote, but it's not resolved. So being not resolved, it's quite possible that a 5-3 vote by this commission is sufficient to let the permit be granted with amendments. My last 2 comments have to do with, and to echo Commissioner Okuda, we're not legislators. We're handed the task of implementing the laws and rules that have been developed before us. And in this case, we have 2 really, in my opinion, extraordinarily bad statutes. The IAL statute, in my mind, I would come close to saying it's a farce. It does very little to protect agricultural land in Hawaii. It does very little to protect the agricultural industry or promote a domestic, robust agricultural economy. And the fact that we can actually have successfully, apparently, put a landfill on IAL lands is further indication of how stupid a statute it is. Similarly, and this is not at all, to be very clear, a criticism of Maui County, but generally speaking, right, the old saying about attorneys is an attorney who represents themselves has a fool for a client. When the counties authorize special permits for their own projects, just by the nature of it, you're never going to get the kind of sharp consideration of conditions that you would if another body was considering them. And it's just human nature. But that is how our process is laid out. And some of the most difficult special permits we've had have been us reviewing permits that were issued by the county for a county project. I think it's a flawed part of the process and should be changed. With all of that, I echo the significance and the lack of desire to have Maui County operate without a landfill. I think overall, based on the limited amount I know now, if this was coming before us with a DBA, I would be inclined to very strongly support the project. But I think it's very clear to me that this is a permanent change in the land, that a special use permit is not the appropriate vehicle for the many reasons stated by Commissioners Okuda and Ohigashi, and I will be voting against the motion. If there's nothing further, Mr. Ordenker, I'd like you to poll the commission.
Thank you, Mr. Chair, although I don't think I really need to. But anyway, the motion is to approve a special permit with conditions submitted by the county, with the two conditions submitted by the Office of Planning, and with the additional condition that the county be required to seek a district boundary amendment within 5 years from the approval of the special permit. Commissioner Cabral.
Yep. And in addition, the two amendments that were offered by OP to withdraw the IAL land within a year and to be sensitive to any burial sites. Correct?
The motion before us is for a motion with 5 conditions.
Yeah.
Approve with the 2 conditions from DEM, the 2 conditions from OP, and the condition voiced by Commissioner Giovanni and accepted by.
Maybe I didn't hear all of that. Okay. Yes, I'm in favor. Yes, thank you.
Commissioner Axon.
Yes.
Commissioner Chang.
Yes.
Commissioner Giovanni.
You're muted.
Aye.
Commissioner Ohigashi.
No.
Commissioner Okuda.
No.
Commissioner Wong.
Yes.
Chair Shoya.
No.
Thank you, Mr. Chair. The motion has 5 affirmative votes and 3 negative.
Which, according to our administrative rules, means the special permit is granted, correct?
That is correct.
Okay. There being no further business, I believe. Are there any announcements, Mr. Ordenker? Otherwise, my intention is to declare the meeting adjourned. Is there anything further, Mr. Ordenker?
Mr. Chair, I just want to once again thank the commissioners for very hard work. This was not easy. None of these have been easy this week.
Thank you very much to all the participants on Maui County and to my fellow commissioners. This meeting is adjourned.